Thank you very much. Good morning, Your Excellencies, ladies and gentlemen, distinguished guests, the Honorable Dato Sri Azalina Osman Said, Minister in the Prime Minister's Department for Law and Institutional Reform in Malaysia, the Honorable Datuk Al-Malena Shamila Dato Dr. Johan, Solicitor General II of the Attorney General Chambers of Malaysia, the Honorable Datuk Sundra Raju, Director of the Asian International Arbitration Centre, AIAC, Professor Emilia Onyema, Director of the SOAS Arbitration and Dispute Resolution Centre, Head of Government Agencies, Senior Government Officials, members of the media, welcome to the International Dispute Resolution Centre. My name is Dr. Amal Maklouf. I am an attorney at law specialized in international dispute resolution. I am a researcher at SOAS University of London, and I am a member of the Management Committee of the SOAS University of London Arbitration and Dispute Resolution Centre. I am deeply honored to stand before you today as a Master of Ceremonies for this prestigious one-day event, the London International Arbitration Colloquium 2023, hosted by the Government of Malaysia, AIAC, the Asian International Arbitration Centre, SOAS University of London Arbitration and Dispute Resolution Centre, and the International Dispute Resolution Centre, IDRC. This colloquium, held in London, demonstrates a fruitful collaboration and strong alliance between AIAC, SOAS University of London, IDRC, and the Government of Malaysia. I'd like to express my sincere gratitude to all our attendees, whether you've joined in person or virtually. As your Master of Ceremonies, my role is to ensure that this event addressing the timely topic of state sovereignty and immunity in commercial arbitration runs smoothly and without interruption. As a sign of respect to our panelists and fellow attendees, I kindly invite you to switch off or silence your mobile phone. I understand the need, the importance of staying connected, but I believe that the content of this conference deserves our undivided attention. The global scope of this conference offers a unique platform for sharing insights with leading dispute resolution practitioners from around the world. And I encourage each of you to participate actively and to engage in meaningful dialogues with our prominent members and participants. To begin this colloquium, I would like to invite Professor Emilia Onyema to deliver her welcoming remarks. Professor Emilia Onyema is the director of the SOAS Arbitration and Dispute Resolution Centre, an independent arbitrator, and a professor of international commercial law at SOAS University of London, where she teaches international commercial arbitration, international investment law, and commercial law in a global context. She is qualified to practice in Nigeria. She is a solicitor in England and Wales, and she is a fellow of the Chartered Institute of Arbitrators. Please join me in giving a warm welcome to Professor Emilia Onyema.
Thank you so very much, Amel. My job is to say welcome. Welcome to London. Welcome to this wonderful colloquium that we have co-organized with the Asia International Arbitration Centre, hosted by IDRC here and the Government of Malaysia. The SOAS Arbitration and Dispute Resolution Centre is not an arbitral center, okay? So we do not administer arbitrations. We leave that to our sister and brother organizations across the world. If you know anything about SOAS, our regional focus is Asia, Middle East, and Africa. But we are a global university, and that is important. And our center is an academic center. So we do research and we share knowledge, both with practitioners, researchers, and academics as well, and students, of course. And we have some of our wonderful students in the room. And that is important because what we do, the work we do, the practice that we all do must be informed by research, by knowledge, as the world changes, as we evolve as human beings, and as a society, a global community, it has to be informed that way so that we can improve the work that we do and the practice that we do. But we are lawyers, ultimately. And as lawyers, we do not begin to engage with life disputes. And that is important because we do know that the issues we're going to interrogate the whole day would have, most of them arose from the Sulu Malaysia dispute, but they are ongoing disputes. And our panelists and speakers are very conscious of that. We're not taking sides because we are an academic institution, but we will interrogate, and we have the academic license to do that. We will interrogate the various issues arising from those disputes. And that is the theme that had informed the theme of our conference today. And this is really important. But of course, we would want to hear views. And we are hoping for a conference wherein our audience and participants, so you're not like those people watching the match between Tottenham and Arsenal. Any Arsenal fans in the room? Sorry, between Tottenham and Arsenal yesterday. Effectively, Tottenham actually scored 3 goals before halftime, you know, and they gave, 2 goals. And then they gave 1 to Arsenal, which was out of the kindness of their heart. I'm not a Tottenham fan. So that is important. But we're not spectators. And that's why you have come all the way here to engage. We want to engage. The beautiful thing is that the government of Malaysia is open to listening. They're open to engagement. Some of their lawyers are in the room. They are equally open to engagement, and that is important. The last thing I would say is about the relationship between the SOAS Arbitration and Dispute Resolution Centre. Remember, it is not SOAS ADL Centre. It is SOAS Arbitration and Dispute Resolution Centre, because we pull in litigation as well. And that remains important. All manners of dispute resolution we deal with, and that remains very important. So it's not an alternative. It is arbitration because that's where we'll get the money from. If we don't have arbitration, the people who will give us money might not look at us twice. So arbitration, that's why arbitration gets a mention. And because most of us do arbitration anyway. And Dispute Resolution Centre. We signed on Thursday, we signed a memorandum of understanding with the Asian International Arbitration Centre. And that is important. The director I have known for a very long time. When I was a little baby, as a lecturer, I knew him. And we've been friends and colleagues, and that is important. And we've signed an MOU to continue to work in our areas of mutual interest. Remember, they administer arbitrations, we support with research, with knowledge exchange across our regions and across the globe. Finally, we are the SOAS Arbitration and Dispute Resolution Centre. We invite all of you because we work with partners. I was saying that to some of my colleagues from the law firms. We work with partners. If you think there's something we should be engaging with, please send us an email. Come over. We're just 30 minutes walk away. You know, come over and let's have a conversation around that. We will knock on your doors and we will want to work with all of you. So enjoy today, engage, ask questions, be better informed. I know that at least you all have met 5 new people. Did anybody fail that assessment? No, congratulations. And so hopefully before you leave, you will meet 5 more new people. Thank you.
Thank you very much, Professor Emilia Onyema, for the welcoming remarks. And ladies and gentlemen, now I invite you to join me in extending a warm and gracious welcome to the Honorable Dato Sri Azalina Osman Said, Minister in the Prime Minister's Department for Law and Institutional Reform, who will deliver the keynote address. Thank you.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera, as you see in Malaysia. His Excellency, the High Commissioner is not here, but represented by his office. The Honorable Dato' Emelina Sharmila, the Solicitor General 2, the Solicitor General 1 from the Attorney General Chambers. Dato' Sundar Raju, my dear friend, the Director of the Asian International Arbitration Centre. My dearest Professor from SOAS, Director of the SOAS Arbitration and Dispute Resolution Centres, esteemed panelists, speakers, moderators, distinguished guests. How do I say it? In a room full of lawyers, when you're also a lawyer, it's an element of time costing. So I hope as we start this program until the end, there's no billing coming in, even to the Government of Malaysia. I have to make that declaration first. That is just a lawyer's joke. This is a great pleasure that I welcome all of you in this special congregation of minds in the third and final series of the International Arbitration Colloquium 2023, with the theme, State Sovereignty and Immunity in Commercial Arbitration in London, the center of the great legal minds. On behalf of the Government of Malaysia, I wish to congratulate our partners, which is the Asian International Arbitration Centre and SOAS University of London Arbitration and Dispute Resolution Centre and the International Dispute Resolution Centre, and their commendable effort and commitment in jointly organizing this colloquium. I would also like to express my gratitude to all the distinguished panelists and the moderators for their participation and willingness to share their expertise and knowledge with us. And of course, a big thank you to the organizing committee for putting this event together and for all the hard work that went along it. Distinguished guests, ladies and gentlemen, allow me to explain the reason why the Government of Malaysia is initiating these ongoing dialogues with experts in the arbitration industry from all over the world. It is to shed light on the precise arbitration practices according to the rules of law and to share our insight with the international arbitration community on the factual narrative of the claims by the purported heirs of Sultan of Sulu against the Government of Malaysia, widely known as the Sulu case, or what I call the Sulu fraud. This particular series today is the result of the collective effort by Malaysia to bring together the international arbitration community for the betterment of the arbitration system by sharing Malaysia's hard-earned lessons from the Sulu fraud. In the Sulu fraud, the purported heirs to the Sultan of Sulu have attempted to extort Malaysia for USD 14.9 billion. That is approximately Ringgit Malaysia 62.59 billion, which is bankrolled by a third-party litigation funder, Territorial. Malaysia has spent a lot of time, effort, and resources to defend our nation from these frivolous claims in the Sulu fraud in Spain, France, Luxembourg, and Netherlands. Despite this predicament, Malaysia realized that what we are experiencing in the Sulu fraud is not unique to Malaysia alone. Instead, it calls for a review of the conduct of arbitrators and for oversight of third-party litigation funders, including exploring transparency and disclosure obligations by relevant parties. Malaysia, from the start, has encouraged and supported arbitration as a preferred dispute resolution. We have the Asian International Arbitration Centre, a reputable global hub for dispute resolution located in the heart of Kuala Lumpur. I am delighted to share, just as last Thursday, as mentioned by Professor, the AIAC signed a MOU with SOAS Arbitration and Dispute Resolution Centre, University of London. This is to foster teaching and research activities related to alternative dispute resolution in alignment with international best practices. Our experience of the Sulu fraud has shown us that the sanctity of arbitration process must always be upheld, and we therefore firmly oppose any abuse of arbitration process, including forum shopping. Today, we will hear from our esteemed speakers in session 1 as they deliberate the role of international arbitrators in upholding the cause of justice and the role of the forum shopping in dealing with arbitration proceedings involving sovereign states. International arbitration proceedings have gained global popularity with or without financial assistance from litigation funders. Notably, many common law jurisdictions traditionally prohibit third-party funding under the doctrine of champerty and the maintenance based on the public policy ground of protecting the purity of justice. As such, it follows that session 2 of this colloquium promises a vibrant discussion on the recent UK Supreme Court case of Pakar, whereby there is a need for third-party litigation funding to be sufficiently regulated to strike a balance between providing access to justice and protecting the justice system in place. The last session of this colloquium, session 3, will set the stage to explore the impact of investment claims on the relationship between the investor and the state, its impact on the economic development of states, as well as commercially viability of foreign investors. I believe our speakers will also touch on how investment claims can be better managed and explore the idea of investment advisory center for states. Distinguished guests, ladies and gentlemen, Malaysia's journey in battling the Sulu fraud has not been an easy task. This has been a case inherited by this government, by my government, from the past government. We did not have the opportunity to address this case from the beginning. If this government of mine, the unity government, had the opportunity, we would definitely have done things differently. But looking on the bright side, the many lessons we have learned from this debacle is why we are here today, to come together and work on the weak links in arbitration process and third-party litigation funding after hosting 2 successful international colloquium in Malaysia on 9 May and 4 July 2023. As a result of this unity's government relentless actions, we have obtained landmark victories in Paris and The Hague for Malaysia and other positive developments in ongoing proceedings in the Sulu fraud. These achievements were made possible through the joint and concerted efforts of the relevant government ministries and agencies under the leadership of the Honorable 10th Prime Minister of Malaysia, Datuk Sri Anwar Ibrahim, who helmed efforts in international relations and diplomacy through fostering joint collaboration to address best practices in arbitration and third-party litigation funding. Malaysia is in the process of obtaining an annulment on the purported final award issued by the rogue arbitrator, Dr. Stampa, at the Paris Court of Appeal. With this annulment, the government's long-standing battle against Sulu claims will come to an end as the basis of the claims would cease to exist, inshallah. This is not only in Malaysia's interest, but also in the interest of other nations, the international community of arbitrators, businesses, investors, and third-party litigation funders. Distinguished guests, ladies and gentlemen, I'm very much confident that our esteemed panelists and all the guest speakers today will bring us through a very exciting journey in exploring the good principles of global arbitration process, litigation funding, and other legal matters relevant to the sovereignty of a nation. We will have the opportunity to then look into the ways to make these systems better so that these processes are intact, facilitative, and not to be detrimental to any parties. To the end, I wish all of you a fruitful discussion, and I hope we're able to come up with glean valuable insights from the wisdom of our panelists and experts today. With that, thank you so much. Thank you for attending, and I hope God is with us in this battle of Malaysia against the Sulu fraud. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, the Honorable Dato Sri, for your words. Ladies and gentlemen, we now move to the first session of the colloquium entitled International Arbitration and State Sovereignty. This panel will be moderated by Dato Feroz Hussein bin Ahmed Jamaluddin. Dato Feroz is a founding partner of Feroz Julian, a dispute resolution law firm based in Kuala Lumpur, specialized in corporate and commercial litigation and international arbitration. Dato Feroz has nearly 30 years of active practice in international dispute resolution. He has appeared before several courts and arbitral tribunals, including the International Court of Justice and the Federal Court on behalf of clients. He has also advised on major corporate and commercial cases across Malaysia, representing both foreign and local individuals and corporations in a variety of disputes. Please welcome to the stage Dato Feroz Hussein bin Ahmed Jamaluddin, together with our esteemed panelists, Mr. Gordon Nardell and Dr. Brendan Plant, along with Professor Catherine Rogers, who is joining virtually. Thank you. The floor is yours, Dato Feroz.
Assalamu alaikum and good morning, ladies and gentlemen. The Honorable Minister, Dato Sri Azalina Othman, and my good friend, Professor Amelia, the Honorable Tan Sri Anifa Oman, the Honorable Attorney General of Sabah, Dato Nur Asia, our new Solicitor General, the Honorable Dato Amalina, my good friend and AIAC Chief, Dato Sundar Raju. So, ladies and gentlemen, it is my pleasure to introduce my panelists. We have on my left, Mr. Gordon Nardell, KC, an old friend of mine who practices from 20 Essex Street in London, and he also practices in Singapore. He's a member of the English Bar and also the Dutch Brussels Bar. Gordon acts in complex international arbitration in cross-border litigation, often involving state bodies and raising issues of both commercial, public, international, and human rights law. Next, we have with us Professor Catherine Rogers, who's a professor of law at Bocconi University in Milan, Italy. She has lectured and taught around the world, including at several US law schools, Queen Mary College, University of London, and the International Dispute Settlement Program in Geneva. And we have also together with us today, Dr. Brendan Plant, who is an associate professor at the University of Cambridge. He is at Downing College, and he's also a fellow of the Lauter Park Centre for International Law at the University of Cambridge. He's a barrister at 20 Essex Chambers, and he is a specialist in public international law. And perhaps this morning we will start off with Dr. Brendan Plant. And I shall invite Brendan Plant to give us a few opening thoughts on whether the participation of a state party in an arbitration changes anything about the arbitral process, its supervision and enforcement, whether it should make a difference if one of the parties is sovereign. I think if Brendan could talk us through a few of his thoughts on this.
Certainly. Thank you, Firoz. Good morning, everyone. Your Excellencies, ladies and gentlemen, Professor Onyema, thank you for your welcoming remarks. I'm very sorry that I let you down and didn't meet you in the appointed time beforehand, but hope that I will make the acquaintance of you and many of you in the room over the course of today. I'd like to say good evening, obviously, to our friends who may be watching from Malaysia, and I suppose buongiorno to Professor Rogers, who's dialing in from Milan. Whichever time zone you're in or language you're speaking, it is clearly a delight to be here today to talk about, well, to talk in the aftermath of the Sulu arbitrations. Obviously, this event takes place in the shadow of that series of proceedings. They are unusual, they are fascinating, they're clearly prominent, and I suggest that they're rather provocative as well. And with my brief time this morning, I wanted to think about and explore the significance of two elements which add considerable complexity to those Sulu proceedings and which pose what I think to be very interesting questions about the scope and utility, in particular, the suitability and limitations of arbitration as a means for settling certain types of disputes today. Those two elements that I'm interested to explore with you today are the elements of sovereignty and history. I will reiterate the remarks that Professor Onyema shared with us right at the beginning. I don't want to relitigate this particular dispute. Goodness knows it's been subject to quite enough litigation already, but I thought it would be useful to draw out some general themes, the instant application of some familiar issues and our encounter of some less familiar elements as well. And I thought it might be useful, given that I am the first speaker of the day, to provide a very brief overview, a procedural history, if you will. I know I've only got 10 minutes, and it's a pretty lengthy overview, a pretty lengthy procedural history, but just a snapshot of where we find ourselves and where we've come from in respect of the Sulu proceedings, so that we're all up to speed for the day's discussions. I'm sure I will leave things out. In fact, time demands that I will. But we are looking at a series of proceedings which have played out in a number of different jurisdictions, emanating from the submission of a claim by the heirs of the Sultan of Sulu under the auspices of the Arbitration Act of Spain. An arbitrator, a sole arbitrator, was appointed. The sole arbitrator proceeded to render a partial award on jurisdiction and admissibility before all sorts of fun and games played out, if I can put it in those terms. The arbitrator's appointment was invalidated. The seat of the arbitration was moved from Spain to France. There were multiple proceedings initiated then before the Paris Court of Appeal, before the Spanish Constitutional Court, before the High Court of Madrid, in an effort to draw an end and to invalidate the conduct of the arbitrator and to stay the effects of the awards which he proceeded to render. The sole arbitrator delivered a partial award and a final award as well. Sorry, I've overlooked our friends in Luxembourg. The Luxembourgish tribunal was involved as well. As things presently stand, the two most recent decisions come from the Paris Court of Appeal and the Hague Court of Appeal, where the nullity of the steps taken by the arbitrator has been confirmed, and the practical effects of the awards delivered denied. There is an awful lot of fairly baroque procedural goings on that I've had to skip over there, but I thought it would be useful to provide that snapshot as we now turn to consider some other aspects. And I wanted to look at what this dispute is all about. What type of dispute is this? Because it resists easy categorization, and yet characterization of this dispute was very important in the proceedings, certainly those which were conducted by the sole arbitrator, Senor Stampa. The characterization is key because it underpins the question of the arbitrability of this dispute, the susceptibility, the suitability for resolution by freely chosen arbitration of this matter, and it formed part of the arbitrator's consideration of the admissibility of this particular question. Just so we're all on the same page, when we talk about admissibility, it's not querying whether or not the arbitrator has the authority to render a decision which binds the parties in the matter, but whether that decision maker should proceed to do so, and it falls within the arbitrator's gift. So what type of dispute is this? On one hand, and as argued by the claimants, the heirs to the Sultan of Sulu, this is a straightforward, or not straightforward, but this is a commercial transaction. We're looking here at an agreement reached in 1878 between the Sultan of Sulu and two maverick private entrepreneurs. There seem to be an awful lot of them traveling around Asia in the 19th century. And these two secured an agreement with the Sultan of Sulu. The agreement was for the payment of a sum annually and for the, let me say, advisedly to avoid the matter, the disposition of certain rights in respect of the territory in what is now Sabah. This was described as a lease insofar as the translations that have been used in the course of the proceedings describes it. I'm sorry to say, my Jawi is a little rusty nowadays, so I haven't been able to verify the translation of that particular document, but certainly there seems to be agreement that the term lease was used to describe it. And yet, the agreement is perpetual. The agreement is lasting. It describes the allocation of the rights which and powers which attain and attach to sovereignty from the Sultan of Sulu to these individual actors. Now, the basis for uncertainty is quite clear. This is a fairly brief agreement struck at a distant historical moment where we don't have the types of details and textures that we might expect of similar instruments to this day. There are plenty of examples of similar types of agreements. Some of these agreements are effective in themselves, or perhaps more commonly, these types of documents comprise a key element in a set of interactions and transactions among various parties with various statuses at various times, which together cooperate to result in something like the acquisition of territorial sovereignty over certain lands by another sovereign actor. So we may query the specific characterization of this agreement as a commercial lease or as something otherwise, something that purports to cede territorial sovereignty in respect of this area to two individuals whose acts are subsequently absorbed, we might say, by a charter company, chartered by the British North Borneo Company. The history of Asia, as I say, is replete with examples of these types of instruments. But one of the points that occurs to me that I'd like to make, as I see that time is already escaping, is the fact that focusing only on parsing the semantics and interpreting the specific terminology of the agreement, which was struck in 1878, need not settle the question of the characterization of this dispute in and of itself. As I have noted, we are familiar in international courts and tribunals with the fact that these types of compacts that look like something sketched on the back of an envelope in some situations, but might be more formalized and developed like this one here, comprise but one element in a much bigger, more nuanced, more textured, and invariably elusive story about the use and potential disposition of powers that properly belong to sovereign actors. I'm mindful of the time, I'm speaking long already, so let me move on to say clearly, whilst there's plenty of scope for disagreeing about the characterization, both of the deed and of the dispute more generally, it becomes a very important matter when we consider the fact that obviously one of the parties to this matter is a sovereign actor, Malaysia. Because as sovereign, Malaysia obviously, and by virtue of its sovereignty, enjoys two incidents: the significance of and the necessity of consent to its participation in and submission to any form of binding dispute settlement that applies in the arbitration context, but under public international law more generally. But secondly, the other face of the coin, if you will, is the entitlement to immunity. And one of the reasons why I flag the significance of characterizing this dispute is the fact that today, in accordance with what has developed into a restrictive doctrine of sovereign immunity from jurisdiction, under the restrictive doctrine, an exception to immunity applies in respect of commercial transactions. I'm painting with a broad brush here, I realize. But if we characterize this dispute as commercial in character, that certainly has implications should the question arise for decision whether or not Malaysia is entitled to remain outside the reach of a dispute settlement framework by virtue of its character as sovereign. I'll proceed quickly then to mention another complication which is closely related, and this is the historical complication. This is a function of history, the complexity or much of the complexity of this dispute. The historical dimension I find fascinating, but also contributes to the elusiveness in some respects of this matter. I think there is cause for us to question the application of concepts like consent, for example, which have developed considerably in the era since 1878, when revisiting and thinking about the facts at issue in this dispute. If a state may only be subject to a binding dispute settlement process with its consent, then we need to think very carefully about whether that consent is present, and if so, its scope. And I suggest that a moment of historical pause is apt in that enterprise. For example, I think of the fact that at the time of this deed in 1878, the now very well-developed legal framework of international arbitration, which is examined and pursued at centres of excellence like this one, this well-developed framework was not in prospect. There were very few thoughts about the elaboration of generalizable notions of international arbitration, particularly when sovereign actors were involved in the mid-19th century. There were obviously some examples of interstate arbitration following the Jay Treaty of 1794, where you've got sovereign actors, what we might think of as an interstate arbitration today. But something like this mixed situation was really up ahead of its time, you might think, given the level of development of the framework we inhabit today. At that time, consent to participation in binding dispute settlement was interpreted very stringently. Furthermore, I think it's worth recalling, sovereign immunity was absolute. at that time. I'm aware, of course, immunity falls to be exercised according to its scope from the jurisdiction that is to be asserted today. But this transition, this evolution from a doctrine of absolute immunity to restrictive immunity, I think should play some role in informing our assessment of, in particular, the consent issue. So I'll finish with apologies for running over time, Firoz, Gordon, and Catherine, mi dispiace. Bearing this in mind, I will express some hesitation. I have a degree of skepticism, maybe even discomfort about the legitimacy of applying a modern arbitral framework, such as that supplied by the national legislation of the Spanish Arbitration Act, as is obviously commonplace in most jurisdictions around the world. The legitimacy of applying these modern frameworks to provide mechanisms which are ultimately administered by national courts, in this case, in order to consider the appointment of a substitute arbitrator in circumstances where the arbitrator is not available. This overlay of a modern framework on a compact achieved at a very distant historical, or rather distant historical moment, I think should give us cause to reflect. I must note, with a degree of regret, coming at this from the perspective of public international law, that we are all too familiar in international law with situations where states freely commit to certain responsibilities, where they freely accept as binding certain obligations, and yet there are no means of enforcement available to hold a state to those freely assumed commitments due to a lack of consent or of submission to the jurisdiction of a decision maker. We are unfortunately familiar with that scenario where we embrace substantive rights and duties, but we flee procedures to make them practically real. It's my sense that the decisions of the Hague and Paris courts practically arrive at a position which is consonant with the ill-ease that I feel about this, insofar as both have ultimately concluded in somewhat different terms that there is not a sufficiently sound legal basis evidencing the consent of the parties to submission to binding jurisdiction. That, I think, is probably a reasonable reaction to some of these swirling doubts that surround our thinking about an absolutely fascinating and, as I say, provocative set of proceedings. Sorry to take so long. Thank you.
No, not at all, Brendan. Thank you very much. Brendan, I'm dying to ask you a question, actually, because you raised some very interesting...
You are quite ill for us.
No, sorry, I'm sorry. But the point here is that you raised some very interesting points about public international law. And what I'd like you to answer is a specific question. If one looks at the passage of time, it's arguable that Britain exercised effective occupation and control until 1963. And subsequent to that, there was a Malaysia agreement and there was independence for the state of Sabah, right? Now, before the grant of independence, there was also a referendum. And here, there was an expression of the right of self-determination of the people of Sabah. How does one tie that in? The exercise of the right to self-determination, the acquisition of title to territory by way of effective occupation and control, and now come up with an 1878 agreement and say, how do you balance the two in international law? How do you say whether one agreement should now be enforced when these separate rights, such as the right to self-determination and the right to title to territory, have accrued over the course of time. How do you balance that out under international law?
Thank you, Feroz, for asking such a penetrating and difficult question right at the start of the day. It's an extremely significant question, and it does not admit of easy answer. Let me share a few remarks though about the question you've asked. The first relates to the mention you've made of effective occupation and control. And of course, we should note that effective possession of territory is but one of the means by which territorial sovereignty can be validly acquired. It is we don't really use the modal analysis. Well, the sole arbitrator in his final award did, but it's relatively unusual to use the inapt and outdated modal analysis for determining entitlement to territorial sovereignty nowadays. But in any case, it makes clear the fact that title to territory and entitlement to territorial sovereignty may only be acquired by means of effective occupation alone in the absence of expressions of consent by a former sovereign to the conveyance of its title to another party, or where there is no former sovereign. And I mean, I don't know if our Malaysian friends will be keen to know this, but I use Malaysian cases to teach this topic at Cambridge all the time, because we have two to look at, to contrast. One is, of course, the Pulau Ligitan case, where the court determined that there was no prior sovereign over the islands in question, and Malaysia succeeded on the basis of being able to demonstrate a more effective use of those islands than Indonesia. In contrast, you might be familiar with the Pedra Branca case. I'll acknowledge that I have some familiarity with this case, and I'm making all of my remarks in a personal capacity. In the Pedra Branca case, the ICJ's approach was premised on its conclusion that the islands and features in question were originally within the sovereignty of the Sultan of Johor. That's an interesting thing for us to pick up on when we think about the Sulu case, because it confirms the fact that in international law and indeed arbitration today, we can revisit and update our sense of the status of those entities and accord them the due respect as sovereigns which they rightly deserve. We recognize that Sulu was a sovereign at the time, just as we recognize that Johor was sovereign at the time. All of which is to say then that British effective possession of these areas is not, from the perspective of public international law today, anywhere near as significant as the expression of consent, given that we know that the Sultanate of Sulu was sovereign. Where does a little detour there, but it's an important one, because again, it focuses our attention on the nature of the agreement that might have been achieved here, but it also, as I mentioned in my remarks, prompts us to consider the way in which that agreement has informed and perhaps structured the dealings between the parties. You know all too well and painfully how a similar type of agreement operated in the Pedra Branca proceedings. There was a lease in respect of the use of the Horsburgh Lighthouse, very similar situation, private British actors given an license to operate a facility on a particular portion of the Earth's surface, which in itself was not enough to assign sovereignty, but became a crucial ingredient in the dealings between the various parties, British, Malaysian, Singaporean, and otherwise, that amounted to what the court considered a conveyance. So that's something, there's an echo here. Finally, self-determination. How does that fit into the mix? The question of balance is one which I think we have somewhat more clarity about today in the aftermath of the various proceedings relating to the Chagos Islanders, where it's been confirmed by the ICJ in its advisory proceedings that the peoples in non-self-governing territories themselves enjoyed rights of territorial integrity effectively, despite the fact that they were not yet sovereign. All of which is to say that that isn't really so much of an issue here, insofar as the British acted somewhat differently, we might suggest, from how they've acted in respect of the Chagos Islands, by giving an opportunity and respecting the choice expressed by the inhabitants of Sabah in fulfillment of their right to self-determination. So the balance is a tricky one, because we have facts on the ground, we have effective uses, we have apprehension and possession of parts of the Earth's surface. But part of what we as international lawyers are insistent upon, and what is important, is the fact that this is structured and controlled by legal processes, and they take precedence.
Thank you. Gordon, a question for you. From what Brendan has addressed today, how do you think one should deal with what can be characterized as sovereign claims arising from historical events, where in purported agreements that may exist, there is an absence of what one would term modern day worded arbitration clauses? I mean, in those agreements may not contain the wording that one would normally expect an arbitration agreement to contain nowadays. How should one deal with such a matter if it comes before an arbitrator?
Firoz, our friendship, of course, is based over many years on
Yes.
your asking the impossible question. I definitely attempting to avoid asking, and I will have a go. But
Yeah,
first,
sure.
a couple of preliminary observations. The first is, can we take as read my echoing of Brendan's remarks, the enormous privilege? Sorry, the enormous privilege of being asked to join in this event in such esteemed company. As a mere practitioner, it's always a particular honour to participate in analytical discussion of this kind, and I'm sure in years to come there will be not just colloquia or lectures, but entire master's courses based on one element or another of the Sulu and Malaysia arbitration. It's just not possible to do justice, even in a session like this, to the whole plethora of issues that it raises, and it doesn't make sense to home in on a number of specific. The other preliminary point is that I haven't fallen out with Brendan. The reason I've attempted a physical rapprochement on the table here with Firoz is simply so that Catherine can be seen by the audience. It's a great shame she's not with us in person, and I don't want to do her the additional disservice of sitting in front of her image on the screen. So let me come to the question. One of the elements of this case that I find most intriguing is precisely this question of how you deal with defunct dispute resolution mechanisms in historic agreements. And it almost invariably, these are historic agreements involving sovereigns. Why? Because sovereigns are essentially perpetual. And so the problems that are caused by these agreements can have impacts that this generation of lawyers are forced to fathom and get to grips with many years after the event. And there's a very interesting question of the relative merits of arbitral and judicial mechanisms for resolving these disputes. Now, there are two interesting equal and opposite forces in the current practice of international law. One is, of course, universalization of international law principles. The other is almost its opposite, the regionalization of international principles. And most of my practice of international law, particularly public international law, is in the European space, as we've had to get to grips with some very difficult questions raised in recent years by the interaction between arbitration, particularly investor-state arbitration, and two bodies of European law. One is EU law, and the other is the law of the European Convention on Human Rights. And one big problem that arose for practitioners and indeed academic analysts following the European Court of Justice's ACMEA decision of 2018 was, well, where do you go? The Court of Justice said, there's a problem with the arbitral mechanism for vindicating sovereign claims against sovereign bodies, but didn't say that the underlying rights have been in any sense annulled. Now, the states themselves effectively achieved that result in 2020 with an intra-EU bit termination agreement. But in the meantime, there was considerable discussion about how parties might vindicate their claims. And Richard Power of Clyde & Co and I wrote a paper in which we suggested the only sensible answer was you had to go to court. And on the basis of ordinary principles of sovereign immunity, the courts of the investor's home state were very unlikely to be able to implead in the absence of consent the authorities of the host state of the investment. In other words, if you're the investor, you still have your rights are intact, but you can only vindicate them in the courts of the host state. And in my view, that isn't a principal problem. If you lose at first instance, you have a train of appeals, and there are safeguards in the judicial mechanisms of modern states. Now, investors, of course, didn't like it, and one's aware of the somewhat disobliging approach that the claimants in this case took to the suggestion of the Malaysian courts, that the Malaysian courts were the proper place to litigate those issues. What intrigues me, and so I'm going to answer a question, but the question is this. One of the interesting elements of this case, and the reason why the Sulu heirs brought arbitral proceedings in the first place, is because they approached the Foreign and Commonwealth Office in the UK and said, look, we have a failed dispute resolution mechanism here because Her Majesty's consul for Borneo no longer exists. Will you please appoint someone? And the Foreign and Commonwealth Office said no. And there's a very interesting counterfactual. What would have happened? I think this would have been my advice to the Sulu heirs. What would have happened if the Sulu heirs had brought judicial review proceedings in the UK courts and said, look, you, the Foreign and Commonwealth Office, have to give proper weight to rule of law considerations, particularly the ability of those who have rights, or at least arguably have rights, in the face of a defunct mechanism to ventilate their claims. That must be a facet of the rule of law of some weight in the face of claims of sovereign immunity from arbitral or foreign judicial process. And interestingly, the English courts have some form in this, in a broadly similar context. And it may not seem similar, but there's a 1990s case in the English Court of Appeal called Swan Hill Developments and British Waterways Board, in which the question arose, how could the heirs of people whose land was expropriated in the 18th century to build a canal bring modern claims for nuisance against the current operator of the canal, the waterway? And the court said, for reasons connected with the rule of law, we will not allow a dispute resolution mechanism to fail merely because the resolution originally contemplated by the parties has fallen into disuse, is defunct. And in that case, they said, so we, the High Court, will exercise the power ourselves by making appropriate declarations. It's very unlikely the High Court in judicial review proceedings could possibly have said, we, the High Court in England, will exercise the now defunct jurisdiction to impede the Malaysian state. But it's very interesting to postulate, well, what would have happened if judicial review proceedings had been brought? And the High Court had looked at that, and I think there's a very strong chance it would have said, well, the Foreign and Commonwealth Office is obliged at least to do something, at least to provide some machinery to take the place of the machinery which is now defunct. And I think that would lead us into a very interesting place about consent and whether that would have been a dispute resolution mechanism acceptable to both parties as a substitute for the original agreed mechanism. So that's the perspective I'd take on this. And actually, this is a two-way street. Many of those in attendance are experts in the field themselves. And I think when we open up the session, I'd be very interested to hear views on the counterfactual. It seems to me that's a logical approach and probably preferable to this dead end of arbitration, to which it's perfectly obvious there was no explicit consent.
Can I just pick up on one thing?
Sure.
One of the things, we've obviously had the delightful privilege of being able to discuss this previously, but I find myself oscillating between thinking of this from an arbitration, an international arbitration perspective and a PIL perspective. Because if I approach this from the angle of public international law, I end up at that position as I mentioned in my remarks. We say, well, it's unfortunate this broke down. That means the default premise is there is no consent. There's no submission. Whereas if you think about it from, or at least I do, from an arbitration perspective, the emphasis seems to be a little bit more on doing more to protect the rights of the parties. Again, premised on a determination that there's agreement to the process to begin with. But the sort of starting expectations are different based on your perspective.
But there might be a third way.
There are
There's
others,
neither
yes.
arbitration nor improper usurpation of judicial power against a sovereign.
Right. Now, Catherine, I know, well, we have to turn around to see you. Could I just very, very quickly ask you this question? Following from what we've just been discussing is whether jurisdiction should be assumed by arbitral tribunals or courts in third countries to deal with historical claims which would impact on what could be characterized as the sovereign rights of another nation. What do you think?
So first, I have to also pause for a moment to express my profound regret that I am dialing in from Milan and not there in what is truly an extraordinary event. I agree, it will hopefully be the first of many. And I also did want to acknowledge how proud I am of my colleagues who also made it very hard to follow up on their terrific remarks. We had a great discussion preparing for this. And Rose has done an amazing job in organizing us and keeping us all corralled. And the organizers, SOAS, the Asian International Arbitration Centre, IDRC, and of course the Malaysian government. I applaud you all and congratulate you in putting together this program. So back to this very nice but tough question about the role of courts in, the role of arbitrators in finding their own jurisdiction, particularly when there's a sovereign. And I can go back to what I thought were some fascinating comments by Brendan, that this is not a static question. It's certainly one that evolves over time. And it's also one that can be refracted depending on the perspective you approach it from. Are we looking at this as access to justice for purported claimants? And at the beginning of a case, we know they are claimants, and we know they purport to have a claim. We don't know if it's a legitimate claim, although I hope to touch later on the concept of frivolous claims. We know there's a concept of sovereignty that has also evolved over time. And we also know that arbitrators, I would argue that arbitrators' powers have expanded tremendously over time. It used to be that arbitrators would rarely, apart from a submission agreement by states, there wasn't really an idea that arbitrators could exercise jurisdiction nearly as broadly as they do. Obviously, competence gives them the power to determine, not finally, but at least preliminarily, their own jurisdiction. And I believe that that doctrine, competence as is generally understood, is when the question is initially presented to the arbitrators, pretty absolute. They don't have to, under the doctrine, say, well, we don't have the power to decide this. We'll refer this question to a court or to some other body to decide whether we can progress in the case. They might decide they can progress in the case. It doesn't necessarily mean, of course, that their decision will be final. A court can disagree with their assessment. But with regard to the evolution of the question of their power, it has expanded tremendously. And I'm going to expand it not only over state parties, but over state interests. I want to highlight a couple of things that are also unique about this case, not just the existence of sovereigns, but that we are talking about tremendous power, and both metaphorically and actually. This is an energy dispute at bottom. And it's also about power to be able to, sovereign power, and the power, I think, of law in its appropriate instances to limit sovereign power. In addition, and I don't think this can be lost, even if it's only been mentioned indirectly, there's just a lot of money involved here. And as with almost all modern energy disputes, we are talking not in the millions, not in the tens of millions, but in the hundreds of millions and billions of dollars. And I think when you have those kind of stakes, it really does alter the complexion of a dispute. And of course, I think it also has implications for how arbitrators approach dispute. Not that they are inappropriately, but the solemnity with which they should approach questions and the amount of energy from the counsel, from the parties. When I say energy, euphemism, time and money poured into making arguments, I think affects how the analysis is conducted. So with that, I'm not sure how fully I answered your question, cognizant of the fact that we have many others to get to. I think I'll pause there.
Thank you very much, Catherine. Thank you very much, Brendan, Catherine, and Gordon for this. Now, can I invite Gordon to say a few words on another topic, which is part of this, and that relates to where a national court rescinds its own defective decision to appoint an arbitrator. Is it acting to uphold the interests of justice, or is it illegitimately interfering with the arbitral process? Can I have your thoughts on this?
Well, many thanks indeed, Firoz. Let me start with some points of very broad context, picking up where the theme that Brendan has just left off, and that is this difficult question of the interaction between public international law and dispute resolution proceedings, in particular arbitral proceedings. I mentioned in my remarks earlier that we're getting to grips in the European space with changes in the relationship between arbitration and public international law through two bodies of law. And I mentioned the ACMEA line of jurisprudence of the Court of Justice. But the other large body of European law that we're getting to grips with in terms of its interaction with arbitration is the law under the European Convention on Human Rights. And there have been a series of very interesting cases which have piqued the interest, if not in some cases the active resistance of what might be termed the arbitral community in Europe, because they seem to have moved the dial in terms of the relationship between state courts and arbitral tribunals, and culminating quite recently in the Castor Semenya and Switzerland case. The European Court of Human Rights seems to be contemplating quite a sharp turn towards a more interventionist approach by state courts in terms of their supervision of arbitral tribunals where there's a European Convention issue. In most cases, that would tend to be a procedural issue if there's a complaint about a lack of independent and partial tribunal. What was interesting about the Castor Semenya case was that the underlying dispute was about the protection of substantive convention rights, discrimination under Article 14. And the European Court of Human Rights was somewhat disobliging about the reticence of the Swiss Federal Court to intervene on public policy grounds. So we're getting to grips with these quite difficult questions of interaction between public international law and the habits or expectations in arbitral practice, particularly when it comes to the question of how reticent, how diffident should the court be in intervening at various stages of arbitral proceedings. Now, the question of public international law that I think informs this question, potentially in the Sulu case, is, as it were, a subset of the large question of sovereign immunity that Brendan mentioned. And that is the existence of an expectation that where attempts are made to implead a sovereign in the courts of another state, then the court's jurisdiction must be invoked through the use of special processes. And that normally manifests itself through national rules imposing particular requirements as to service. And those rules on the international level recently have attempted to be codified in the Hague Service Convention. But I think it's generally accepted that if not customary international law, then certainly usage among states is that where a state body is sued in the courts of another state, then special methods generally have to be applied under national procedural law to properly communicate the court process to that state. And generally that involves service through diplomatic channels. And that national rules giving effect to that subsidiary element of the principle of sovereign immunity were at the heart of the dispute that's just been considered by the Hague Court of Appeal on the question whether the final award made in favor of the Sulu heirs should be enforced in the Netherlands. It was precisely the failure of service that gave rise to this problem. Now, having set the scene with public international law, I do emphasize that the element of this case I'm dealing with is actually a very narrow element, but a very important element, because this question of the effect of a failure to observe the proper rules in Spanish law for service of process on the Malaysian state was at the very heart of the decision of the Netherlands court to decline to recognize and enforce the Sulu heirs a final award under the New York Convention. And there's a real question as to whether public international law actually has anything to say about this at all. And what I'll do is let you answer that question, and I'll explain how the Hague Court of Appeal dealt with the question, and then look at one or two issues that have been left unsaid, and then look at the question whether this is one of those situations, if we're left in some doubt as to how those principles play against the background of the expectation that courts will generally be reticent to intervene in pending arbitral proceedings. I'll just look at the question of whether this might be one of those situations where the public international law context moves the dial in terms of the willingness of the court to intervene. Just one small piece of disclosure along similar lines to Brendan's comment about involvement in a case. It's not a secret that I undertake professional work on behalf of and occasionally against various Malaysian state entities. And I have had the privilege of some very peripheral involvement in discussions about the present case, but I certainly haven't been instructed in any of the proceedings. But I think given the context, full disclosure is appropriate. So my views and analysis, including any errors, are mine alone. So just a reminder then about how this particular issue of service on sovereigns arose in the Sulu case. And I'm just going to pick up one element of the broad procedural history, which Brendan explained in overview. You'll recall that the large issue in the background to all this is whether the 1878 agreement contained an arbitration clause at all. But what it did contain was a now defunct dispute resolution mechanism. So whatever the dispute resolution mechanism in modern terms that now felt to be engaged, it was very likely that a person could only be appointed to exercise that power with the involvement of a national court somewhere. And that's the background to the particular problem which arose in this case, because the arbitrator in this case was appointed by an order of the Superior Court of Justice of Madrid in 2019. And it turned out that the summons issued by the Suluers seeking that appointment had not been properly served on the Government of Malaysia under the Spanish national rules, which give effect to the principle that, generally speaking, there are special rules of service where a sovereign is impleased in another state's court. And therefore, the Government of Malaysia applied in 2021 for rescission, for annulment of the original order made in 2019 by the Spanish court appointing an arbitrator. And the Spanish court accepted that there had been a defect in its process. And the result of that defect was to make its earlier order a nullity. And it made an order declaring the nullity of its original appointment of the arbitrator, Dr. Stamper, and also directed in its order that all subsequent proceedings in this case, here's where the problem arises, all subsequent proceedings in this case are also a nullity. And there's a very interesting question which the Spanish court didn't directly resolve as to whether it was referring to all subsequent proceedings in the judicial appointment process or all subsequent proceedings, including the arbitral process, which by then had got very significantly along the road towards a final award. Dr. Stamper had by then made a preliminary award, accepting jurisdiction and fixing the substantive law governing the dispute, and had gone some distance along the road to producing a final award. So that first dispute was, well, which proceedings was the Spanish court referring to? There's also a dispute as to whether the Spanish court made an effective order directing Dr. Stamper to cease purporting to carry on those proceedings. There was a particular dispute as to whether that was part of the judicial content of the Spanish court's order or merely an interpretation of that order by non-judicial officials in a communication to Dr. Stamper. And I don't take a position on that, and that wasn't resolved by the Hague Court of Appeal. And who knows, that issue may well live to fight another day, but there's a dispute about that. But at all events, the court ordered what it ordered. The arbitrator himself, Dr. Stamper, treated the Spanish court's subsequent order annulling his appointment as an improper intervention in pending arbitral proceedings, contrary to the spirit, if not the letter, I think it was Article 7 of the SAA, the Spanish arbitration law. And he took the view that that intervention, because of its illegitimacy, was ineffective to prevent him from carrying on in office. And he made an order, procedural order number 42, indeed the number of orders, procedural orders that were made in this case is testament to their complexity. Procedure Order 42 declaring that he himself remained in office and staying the proceedings until certain questions were resolved. And subsequently, he made Procedural Order number 42, purporting to move the arbitration to France. The Court of Appeal in Paris has since annulled the exequatur that was given in France to Dr. Stamper's preliminary award. It hasn't annulled the preliminary award. It can't, because at that time, it's common ground that the seat was a Spanish seat. But what did happen was that and Brendan touched on this, there are proceedings pending in the Paris Court of Appeal to annul the final award with its purported French seat. And the French Court of Appeal suspended, it stayed the effect of the award in the meantime. Now I mention that because that's all relevant to the way the Hague Court of Appeal dealt with this. And depending which part of the Hague Court of Appeal's judgment from June this year you look at, there are either one ground and two subsidiary grounds refusing recognition of the final award, or three equal and self-supporting grounds. And I think probably there's one primary ground and two supporting grounds. And the primary ground was this, and it has a deceptive simplicity to it. The Hague Court of Appeal said, well, it's all very simple. The Spanish court rescinded the authority it gave to Dr. Stamper to act as arbitrator. That's the end of the matter. By the time he came to purport to make a final award, he simply had no power to do so, because his power was terminated by the same court which cloaked him with that power in the first place. And the Hague Court of Appeal refused enforcement on, I think, on a fair reading of its judgment, that primary ground. It also refused it on two other grounds. The first was that there's no arbitration agreement at all, and the second was that in its discretion, because the Paris Court of Appeal had stayed the final award. Was another good reason under the New York Convention, but it seems to me on a fair reading, the primary reason is to say, well, under the New York Convention, all that the National Court can do is enforce an arbitral award. This wasn't an arbitral award. Effectively, it was a simulacrum of an arbitral award because it was given by somebody without authority. Now that raises for arbitration practitioners quite difficult and deep-seated question about the role of the court and the legitimacy of its intervention in pending proceedings, and in particular, its relationship with the competence principle. Now, the Hague Court of Appeal didn't grapple with this. It rather asked itself a different question. It asked itself, can we say that the later order of the Spanish court rescinding Dr. Stamper's appointment fell short of the essential standards of due process? And it said it couldn't. In an ideal world, it said it would have a sort of further round of comments from the Sulu heirs on a specific question on the weight to be given to a letter from the Spanish Foreign Ministry. It didn't do that. It should have, but the process as a whole was completely compatible with the process, with the requirements of due judicial process in states governed by the rule of law. Now, that's actually very similar to the kind of questions that the English court asks when it's invited to decline to enforce and recognize an award under the New York Convention that has been set aside in annulment proceedings at the seat. It will take the view that in principle, if an award's been set aside at the seat, there's no award, but there's an exception where the set-aside proceedings were themselves conducted in defiance of the essential requirements of due process. And so in general terms, among European states at least, the Hague Court of Appeal has gone along with a consensus in examining the question of judicial process. But I don't think we can dodge that question quite as easily, because I think it does raise difficult questions about this issue of the proper relationship between the National Court and pending arbitral proceedings, not least in the context of human rights, where the European Court of Human Rights has on more than one occasion taken a very dim view of intervention by other state bodies in pending arbitral proceedings. So what's the answer? Does the Spanish court's approach compromise the important principle of competence? And the answer, in my view, is that it doesn't. And that is because the competence principle is fundamentally related to the substantive jurisdiction of the tribunal, at least what English practitioners would call substantive jurisdiction. Is the dispute arbitrable? Is there a valid arbitration agreement? And so forth. that it doesn't have quite the same impact on what I suggest is a different question, and that is the authority of a particular person to exercise the powers of the tribunal, including the power of the tribunal to determine whether it has jurisdiction. And that's a different question conceptually. However, in most cases, and this is what's so interesting about the Sulu case, in most cases, that question of arbitrator authority is masked. And it's masked because, generally speaking, 99% of the cases that give rise to judicial disputes about arbitral tribunals' jurisdiction and competence, there's an explicit arbitration agreement which provides a method for appointing an arbitrator. And very often that will involve the incorporation of the rules of an institution, which will make specific provision for what happens if an arbitrator is removed. In the case of a three-person tribunal, it will very often contain rules prescribing how the surviving members of the tribunal may continue pro tem until an arbitrator who's been removed has been replaced. We don't have the luxury of that masking in this case, and therefore we're forced to answer the question directly: what is the source of authority of an arbitrator who's appointed under an agreement, leaving aside the difficult question whether it was an arbitration agreement at all, but under an agreement that doesn't provide an explicit mechanism for appointment, removal, replacement of arbitrators. And therefore, in the absence of such provision, the only way in which a person could be appointed to exercise the powers of the tribunal is by an order of a state court. Now, it may well be that on the level of legal theory, the competence of the tribunal ultimately derives from the arbitration agreement. But if the arbitration agreement either makes no provision at all for appointment of an individual, or the machinery for appointing the individual is defunct, and the national court steps in order to rescue the machinery, it seems to me that if one asks the question, what is the source of the authority of the person appointed to exercise the power, to exercise the jurisdiction of the arbitral tribunal, that is susceptible of only one answer, and that is the source of authority is the order of the national court. And therefore, where the national court finds that there was a defect in its original order and decides that it must correct the defect by rescinding its original order on the basis that that order was a nullity, it seems to me that that's the end of the arbitrator's authority. And therefore, my respectful suggestion, and this may prove controversial, is that the Hague Court of Appeal was right not to go behind questions of the appropriateness of the Spanish court intervening, because in reality, the Spanish court wasn't intervening in pending arbitral proceedings at all. It was merely undoing, for good reasons, what it had done in the first place. And in this case, the good reasons were ensuring the proper observance of national rules of law, which have in their arrière-plan, as it were, the public international law rules on the particular provision of sovereigns. Now, I'd suggest that in this case, it so happens that the defect in the proceedings were defects that are linked to a public international law source. But I don't think that's necessarily, as a matter of logic, the only basis on which it was proper for the Hague Court of Appeal to recognize the Spanish award in the way it did. In my view, even if there had been no question of public international law, if one's asking which side of the line was the Spanish court's intervention, it was the side of the line of properly correcting a nullity rather than illegitimate intervention in pending proceedings. And it seems to me one has to ask the question, well, what was the court supposed to do? Should it have simply waited until the end of the proceedings to see whether there was any attempt to set aside the upshot of the proceedings before the Spanish court, or an application to the court to recognise and enforce in the domestic legal order? And it seems to me that as a matter of case management, that would have been most unwise. Once the court has decided that this is a purported appointment of an arbitrator that never had any validity, the right approach is to put that purported appointment out of its misery. In other words, to say this was an arbitration that should be stopped, and stopped now before the parties incur further costs. Why? Precisely so that the parties have an opportunity to put things right. And the Spanish court was adamant that it was open to the claimants in that case to make a fresh application on proper notice to Malaysia for a fresh appointment, which in fact they did. And for reasons which I have to say I don't entirely follow and will not speculate on, the application was then withdrawn. So in terms of that principle of the rule of law, which requires that claimants under a historic agreement providing for a defunct dispute resolution mechanism should have a proper opportunity to ventilate their claim. It seems to me that if that's the test, the Spanish court passed that test. And it's actually not necessary to ask the question, well, should there have been some discretionary power in the Hague court to go behind the Spanish court's order? But if it is necessary to broach that question, it seems to me that, well, we're all getting accustomed, as I said, in the European space these days, to public international law considerations moving the dial in terms of the circumstances in which what might otherwise be an undesirable intervention by the court in pending arbitral proceedings may well be acceptable and indeed necessary. But in my view, that's no more than a factor, and probably a subsidiary and not very weighty factor in the proper analysis of the position in this case, which was, as the Hague Court of Appeals so simply put it, once the Spanish court had rescinded as a nullity its original appointment of the arbitrator was an arbitrator no more. And the Hague Court of Appeal was right to say that what it had in front of it on a request for recognition enforcement was in substance not an arbitral award at all. Now, I think just before I shut up, that there are a couple of distinctions that's important to make. The first is, I think it's important to distinguish this rather unusual situation of the court rescinding its earlier order on the basis that the earlier order was a nullity from what often happens in other situations, which we're all more accustomed to in arbitral proceedings, where someone applies to remove an arbitrator at half time. So someone discovers that an arbitrator has failed to disclose a relationship with a party or some other disqualifying interest. A request is made to the arbitrator says no, and in certain situations it's appropriate then to apply to the court at half time to remove an arbitrator. And I understand that there are different philosophies as to whether it's appropriate for the court to intervene at that stage or wait to the end. I think this is distinct from that situation. This is not about whether someone who's originally properly appointed and cloaked with the authority to exercise the powers of the tribunal should subsequently be deprived of that authority. It's a situation where the court is saying, actually, we were wrong, and this person should be treated as never having had that authority at all. So in the circumstances of this case, I think the Hague Court of Appeal was right, so far as it took this view, to say this isn't an illegitimate intervention in pending proceedings, and the Occam's razor simplicity with which it drew its conclusions, it seems to me, was entirely justifiable. So I'll leave my thoughts there, and I just have a suspicion they're not going to be entirely shared by every other member of the panel.
Now, very, very quickly, thank you very much, Gordon. I know Catherine probably has a slightly different view. Just a very quick comment, Catherine, on the issue of where does an arbitrator's power come from?
So I think the allusion is to this very robust debate we had actually Friday and the weekend and whatnot. I'm not sure if there's so much space between our views. I guess I would say procedurally, or I'd be a little more inclined on the technical side. I think, I believe that a decision by a court, even if there's, as we have here, a very vague arbitration agreement that does not include appointment mechanisms or an explanation of how arbitrators would be appointed, it is the finding that exists an arbitration agreement that precipitates the court to say they're going to appoint an arbitrator. I think the point of agreement that we have is it's at least possible in extraordinary circumstances that we have here, that a court could decide that they have erroneously appointed the arbitrator, and they could, in a sense, suspend that decision. And I guess the point we do disagree with, and again, I'm not sure it really affects the outcome, is I don't know that in a sense automatically eliminates the arbitrator's authority per se under competence. If, I mean, to take a more, I guess, neutral or abstract analogy, if the arbitrator sort of was a fraud, was an imposter, so this imposter arbitrator was appointed and a court says, oh my gosh, we accidentally appointed an imposter, I mean, clearly the court needs to be able to say that. I would say the mechanism for that should follow then is an anti-suit injunction in the court saying you found there's this profound defect, the arbitration needs to stop, issue an injunction. I think the vagaries that were being referred to earlier by Gordon about what those orders actually said, would have been added some clarity here about what needed to happen next. On the other hand, it's also possible to imagine that an arbitrator has been legitimately appointed is initially, and that a court, as a result of corruption or error, later decides that that appointment was an error. I think in that instance, the arbitrator continues to have competence. His or her authority does not, in a sense, disappear, but continues. That doesn't prevent the courts, however, from issuing an anti-suit injunction and saying you must stop. And then there's a whole cascading set of events that might follow based on the implications and effects of those orders. So there's not much daylight between us, but we did have certainly a fun and interesting discussion about the nature of arbitrator authority and the source of it.
Thank you very much, Catherine. Catherine, since we are slightly running out of time, I'm being told by the organizers, can I have your general remarks? Because as you specialize in the ethical role of arbitrators, can I just have some general comments on an arbitrator's role regarding their primary ethical obligations and the rule of law, meaning the obligation of impartiality, to ensure fairness and integrity in proceedings, to apply the law, subjects like those, the ethical considerations.
Super. I welcome this. Thank you very much. I'm actually going to start with, I think, two quick anecdotes, thumbnail sketches of earlier cases that I think will help frame my remarks. So the first case is 1999. It involved the Indonesian State Electricity Company, an investment case. And in that case,
Yes, I was wondering if you could go a bit closer to the mic, because
Can you
sorry,
hear me now better?
it's still a little bit soft. I don't know whether it's on our end, which is a problem, or.
So I haven't changed any of my settings. Maybe if I speak up a bit.
Yeah, that's fine. That's fine.
All right, thank you. So in this arbitration, it was an investment arbitration against the Indonesian State Electricity Company. The state allegedly was harassing counsel and even the arbitrators. It had its courts had issued an anti-suit injunction to the tune of $1 million a day fines back in the 1990s. And the arbitral tribunal in that case determined that the anti-suit injunction was a violation of international law. And it also, not unlike in this case, relocated the arbitration to The Hague in response to what was understood to be a hostile situation in Indonesia. The outcome of that case, interestingly enough, was allegedly the state of Indonesia kidnapped its own party-appointed arbitrator to stop the arbitrations. So a little more dramatic than what we have here, but nevertheless, there are some themes that are similar. Now flash forward to 2011. One theme similar in this case is that it is once again an older purported arbitration agreement, but not quite back into the 19th century. It's in the 20th century, 1933. There are also errors involved, errors meaning descendants of the people who had originally purportedly signed the arbitration agreement. The case was Saudi errors against Chevron, again, an energy case. And in that case, the tribunal initially decided that it did not have jurisdiction, but that's when, according to the district court in the United States, charitably put, things got very interesting. The arbitral institution replaced the arbitrators. They then, in a second ruling, issued an $18 billion award, and the arbitral institution purported to award itself $23 million in fees. That case resulted in criminal charges brought in Egypt at the behest of Chevron, as well as other places. I raise these cases because there is something similar, or there are some themes, some ideas, and certainly some events that seem similar with ours. And that's a premise for introducing the idea that the job arbitrators have, international arbitrators have, is incredibly complex. When they first come to the dispute, they come with an open mind, so they don't know necessarily that the claimants are fraudsters, or their claim is frivolous, or that the state is inappropriately bullying. And another way this comes up in international arbitration consistently, I believe today, is in claims of corruption. And states will begin criminal proceedings against an investor, arguing that they've engaged in financial improprieties, and how the arbitrators exercise their power, which have included some injunctions against states pursuing criminal actions, really demonstrate, I think, the importance, the incredible weight of an arbitrator's decision-making. So long wind-up for saying what are their obligations. So their most fundamental obligation, of course, is impartiality. The way we test that in individual cases is through challenges, usually based on factual disclosures or discoveries about the arbitrator's relationships. I want to touch on just a few more abstract ideas about impartiality that I think are in the background of some of our considerations today, and are some of the ideas or themes that drive the press, both for a new code of conduct for arbitrators in investment arbitration and for calls for elimination of investment arbitration altogether. I will also, before I go into the substance, say I'm a true believer in international adjudication in the role of arbitrators. So I worry sometimes that arbitrators bear the unfair brunt of some of these criticisms. On the other hand, they do have, I think, a lot to contribute to perceptions of their own legitimacy. So one of the critiques that exists for international arbitrators generally under the umbrella of impartiality, but not technically challengeable as the question of impartiality, is there's been at least alleged that arbitrators have a certain self-interest in finding jurisdiction. And that's in part because they get paid, compensated based on how much time or how complex the case is. Obviously, if it's dismissed early on jurisdictional grounds, the idea is they might get paid less. I'm a little wary of this critique, even if I think there might be some truth to it historically, because actually every court is sort of known for expanding its own jurisdiction or taking an expansive view of its own jurisdiction, dating back to the US Supreme Court in Marbury versus Madison, created the entire idea of judicial review, the European Court of Human Rights, the European Court of Justice. I think it's inherent in the nature of being an adjudicator. But as individuals who are individually compensated per case, I do think it's something arbitrators need to reflect on. In addition, and sort of related to it, I think certainly in international commercial arbitration, there is this concept, a very vague concept that my colleague from their statement, George Berman, has written a lot on. There's this concept of pro-arbitration, and that we should all be pro-arbitration. And he critiques that concept as being really a flat instrument from which to try and craft particular doctrines or rulings. Certainly, we want to have arbitration agreements be presumptively valid and only questionable or blocked under rare circumstances when they cannot be demonstrated to have been actual consent and validly drafted. But pro-arbitration is not when, for example, there is an instance of violation of public policy, of rampant corruption, for example, by one of the parties in the arbitration or in the underlying dispute, perhaps, that gave rise to the arbitration. And nevertheless say, well, pro-arbitration means enforcing that arbitral award. So I think we need to consider this quote unquote bias, let's call it. I think that's sort of also a vague term to be using it in multiple different ways that we don't acknowledge. But the idea of pro-arbitration is a type of bias we should try and avoid. In addition, I think fundamentally one of the obligations of arbitrators in demonstrating their impartiality is to police the boundaries of the arbitral process to ensure that it is fair and that they uphold the integrity of the proceedings. Now, upholding the integrity of the proceedings and ensuring fairness does not necessarily, I believe, mean treating the parties identically. Claimants, by definition, have certain advantages because they bring the claim, they frame the claim. Respondents have perhaps other advantages in the sense they get to respond. Sometimes they have the last word. So even in the procedures, it's not the assumption is not they're entirely equal. I think when we do have state parties, many tribunals have recognized they have some unique challenges that private parties do not face. And taking consideration of those concerns is not an imbalance, but in a sense, an effort to create fairness and integrity in the proceedings. With regard to the obligation to apply law, this is a really challenging one. We assume that arbitrators and arbitral tribunals are obliged to apply the law. However, when you have systems upon systems that interact, we've been talking today about public international law and international arbitration, but there's also all sorts of other layers that come into play, as we've seen in the discussion of the case, of any complexity. And so the idea of what the quote unquote law is becomes much more attenuated. It gives arbitrators a great deal more discretion. And it is an exercise in that discretion, I believe, that they need to be cognizant of their own sense of legitimacy. In courts, we read the outcomes and people assess the legitimacy of the court. If you're looking for an example of an esteemed court that has been able to radically undermine its own legitimacy, both with regard to some of its recent rulings and with regard to some of its behavior in violation of what other courts are bound to in terms of ethical conduct, you can look at the US Supreme Court. Let me touch a couple of other things because I know we have some students in the audience. One of the things when I teach, as I will be shortly after this program today, my international arbitration students, I tell them arbitrators are sort of magic, right? They're just ordinary individuals, but they have a sort of magic wand because when they make an order under the New York Convention or other conventions that will enforce the arbitral award, the award is given the same dignity in national courts as a judicial judgment, which is kind of amazing if you think about it. And for that reason, arbitrators are given arbitral immunity from civil suit, which means that they cannot be sued civilly. Different jurisdictions have some exclusions. For example, if they act in bad faith, in England, I believe is the standard. In the United States, it's actually absolute immunity. So even if an arbitrator is caught bribing or accepting a bribe, they would be immune from civil suit. Arbitrators are not, however, immune from criminal prosecution. And that we see, there was a criminal order issued against the against the arbitrator in the Sulu case, which is interesting because there remains, at least from the outside, some ambiguity about what the judicial order was that supposedly led to the criminal allegations of criminal misconduct. But arbitrators have one form or another immunity, and I think that that's really an important indicator that arbitrators are not mere service providers like a plumber or an accountant. They are charged with something larger, namely issuing an order or decisions that are consistent with a greater sense of justice, usually bound on, not always, parties can sometimes agree to have principles or other sources determine the outcome of a decision, but certainly with the greater sense of the rule of law. I think in these troubled times where we see some eminent international organizations and even international courts like the WTO having breakdowns and challenges given the political climate globally, I think international arbitration is more important than ever. I believe it all rests on the integrity and performance of the, of the arbitrators. And so I think one of the things we can look at in this case is the role of the arbitrator in securing the rule of law and also acting with integrity when we have, and I won't go to it now, but either rogue parties, rogue courts, arbitrators' abilities to manage these three-dimensional problems in happening on multiple boards all at the same time creates tremendous challenges. But the best arbitrators, I think, have been able to do it, and I look forward to seeing us not shy away from arbitration, but finding new ways to strengthen it, including by making more clear the ethical obligations of all the actors involved, not just the arbitrators, but the parties, the council, and third-party funders.
Thank you very much, Catherine. Well, it gives me great pleasure to thank all our panelists. I'm now opening the floor to questions to our distinguished panelists because I've been informed by our organizers that we are running out of time. So please, ladies and gentlemen, Mr. Philip Coe, my good friend.
Thank you, Philip. I want to thank the esteemed organizers and the esteemed panels. I would like to just make nature of one remark and then maybe two short questions. I think listening to the panelists, I draw inspiration from the writing of Quentin Skinner and Hent Calmo, where he talked about sovereignty in fragments. I think this resonates with Dr. Brandon Plant's comment about the absoluteness of sovereignty has actually been restricted in the modern arrangement of state arrangements, and of course in the arbitral commercial world, especially linked to the New York Convention. I appreciate in particular Professor Catherine's comment on power relationship, where again the Cambridge professors in that book talked about the fact that the whole concept of sovereignty is now a liminal one, interacting with political, historical, legal. And I think one helpful distinction I drew when listening to the panelists is we have facts which are inexorably there, whether or not it's from an 18th century agreement or by some succession of treaties. And then we have the normative framework of which these questions are being interrogated. With those brief remarks, I'd like to ask two short, brief questions. It may not be answerable. As Gordon puts it, we are all in an unanswerable situation at times. Would the right party to be sued not Malaysia, but Britain? Why didn't the Suluk sue the Britain, since there was an agreement which somehow disappeared through brutal facts of succession and handing over power? The next one is a larger question, probably can't be answered in a short compass. The whole revisiting of New York Convention. The New York Convention has over 6 decades old, and there has been academic literature relating to whether it ought to be revisited with certain stratification or nuances learned from perhaps even in a lesson like we have been listening of the event of the Sulu claim. Thank you for the opportunity to make those remarks.
Brendan.
Do you want to take a
Sorry.
Take a few minutes.
Question so that the panel can deal with that. And that is the idea with the arbitrators themselves. As you can imagine, I'm a fan of Catherine's work, and I very much believe in her thoughts and the ideas she publishes. But a few years ago, when Cambridge and Lord Hoffman then said that we arbitrators, we forget that we're not judges. And so the question really is that correct? What is the difference between an arbitrator and a national court judge? It sounds really simplistic, but it's not. So one of those difficult questions again.
Right. Brendan, can we start?
Sure, I'll pick up on a few elements, and of course, they'll be the easy ones. I'll leave the hard ones for my colleagues. Professor Koh, you mentioned the facts are there. I wish that were true. The facts are so often made in the context of specific processes that they aren't there to just be found. And so I would just nudge back a little bit on that particular remark, because I think one of the implications of that for our discussion today is the choice of forum, the choice of who decides that ageless, deathless question about the appropriate manner of proceeding when legal rights and responsibilities are at issue is a really important one, not only when thinking about the interpretation and application of the normative framework, but also in the determination of the facts to which that framework must be applied. So, and there is a lot of scope for differences of approach to the fact-finding task of sole arbitrators, arbitral panels, international courts and tribunals, and so on. As for your question as to who is the right party, is it the UK? And I think there's a lot of enthusiasm for pursuing the UK about a lot of things at the moment. Couldn't possibly imagine why. We'll censor that out of the internet stream, I'm quite sure. But I didn't go through some of the intricacies of the succession issue which is involved. But the question is, of course, what is the trigger for the dispute, and it was the non-payment of the rent on an ongoing basis and the arrears. That is something which has, of course, occurred after Malaysia has succeeded to Britain's claims in respect, administration in respect of North Borneo. One of the fascinating things here is that Malaysia has succeeded on both sides. Obviously, Sabah is integral to the Malaysian state, as of course is the territories that are involved in this arbitration. So they're on both sides of the fence. I'll pick up on one last remark, though, in response to Professor Onyema, and in response to some of the excellent comments that Professor Rogers has shared. Professor Rogers mentioned that she doesn't, when teaching arbitration, she tells her students that arbitrators are not service providers, which is interesting because I teach the exact opposite. I think that there is a reasonable basis for thinking that the primary task is the provision of the service of settling in binding manner a dispute, and that there are obviously cascading effects and important secondary issues. But at the end of the day, arbitration is about providing that particular service, and there is a marketplace. It's the same with international courts and tribunals, frankly, nowadays. I think even the ICJ can be referred to as a service provider. But I say that merely to indicate that there is obviously a variety of perspectives on what might not be a binary, but a spectrum determination of the differences between arbitrators and judges.
Gordon, final remark on arbitrators not being judges.
Indeed, and the difficulty is we increasingly expect arbitrators to behave like judges. We develop principles internationally and in individual jurisdictions with increasing sophistication, holding arbitrators to very similar standards to those to which national judges are held in terms of disclosure, maintenance of independence and impartiality, and rightly so. So perhaps we can forgive arbitrators if occasionally they think they're judges.
Can I jump in? I'm sorry.
Any other questions?
Can I jump in one moment on that?
Yes, Catherine.
So first of all, this panel's going to have to meet somewhere again because we've only had too much fun and addressed half the issues. But I want to poke a little bit back on this because what I teach my students is that arbitrators are super judges, not just judges, but super judges. Number one, they have way more discretion, right? They are not bound by federal rules of civil procedure or rules of evidence. They get to make them all up. Number one, they're not bound by appeals because there's no substantive review of their decisions. They have immunity. If they do something wrong, they're mostly immune. And they are also not members of a bar like lawyers, so they can't be disbarred or disciplined. And one of their, I would say, mechanism for controlling judges is that their judgments are all public. And so even if judges are independent and intentionally cordoned off from political units, they can be subject to citizen backlash, let's say. Now, just because I say that they're super judges doesn't mean I disagree with Brendan, because I think we ultimately end up agreeing on pretty much everything. They are clearly providing the service, but the service they're providing is adjudication. And I think that's very different than providing, for example, plumbing services. Adjudication is much more complex. It's embedded in a legal regime and is expected to provide and contribute to the rule of law. And in that sense, I think it's, it comes back down to definitions. What do you mean by service or service provider? But I think that the service they're providing is justice. And I think that that is inherently different and calls on arbitrators to do something much grander than just adhere to the the four corners of the parties' agreement, but rather to have skills and knowledge and an eye towards the world outside that agreement.
Thank you very much, Catherine. Any final questions? Oh, yes, the gentleman over there, Alex. Yes, go ahead. Oh, sorry. Alex is from Mishcon de Rea, law firm in London. Alex.
Thank you, Justice
One of
Feroz,
the
for the
people I met this
introduction.
morning, Professor.
This was just a question / request for clarification to you, Gordon, just about your comments on the authority of an individual arbitrator as compared to, I think you contrasted that with substantive jurisdiction. I may have misunderstood what you were saying, but it seemed to me you were suggesting that the authority of the individual may not be an issue that falls to be determined by the tribunal as a matter of competence. Obviously, this case is a particular scenario where you have no potentially operative clause, and so a national court has stepped in and appointed. But of course, there are many different varieties of appointment. It could be a national court because of a failure of the appointment process. It could be an institution because of a failure to appoint, or because of the clause just leaves it to the institution. It could be an ad hoc appointment. And you may have scenarios where a party is challenging the individual and compliance with whatever the appointment mechanism might be, rather than, say, the operation of the arbitration agreement in the first place. So in that context, are you suggesting that those decisions would not be determined by the tribunal under competence, or is your suggestion something slightly different? Because I'm thinking, in particular, Section 30 of the Arbitration Act here suggests that the constitution of the tribunal, which could be interpreted as the authority of the individuals, is a matter of substantive jurisdiction and therefore can be determined by the tribunal. I was just interested to see where that thought process was leading.
Gordon.
No, thank you. And you're right to interrogate that point. And I was careful to, as you probably noticed, to make clear that my analysis is linked to the facts of this particular case, because in most cases, as you say, and probably the vast majority of cases, you will have some other mechanism where the tribunal may well have to find facts and apply the law to questions of its own composition, which could be argued to be questions of authority. But in most cases, that's masked precisely because the arbitration agreement will provide some mechanism other than the national court itself for appointment of arbitrators and determination of the question, what's the scope of their authority. So I think it's important to understand that there may well be cases outside the scope of the situation that we're dealing with in the Sulu case, where the question of an individual, the propriety or the validity of an individual arbitrator's appointment, and therefore that person's power to exercise the jurisdiction of the tribunal resolve the dispute, will turn on matters which it's perfectly within the competence of the tribunal to deal with. But rather like a first instance judge, that's not this case. And it's very difficult to trace back the authority of Dr. Stamper in this case to anything other than the order of the Spanish court appointing him. In that situation where you have this particular question posed in all its purity, I think in that situation, the answer is pretty clear. You can test it in this way. Would Dr. Stamper have had any business trying to determine for himself the question whether the order of the Spanish court appointing him was a nullity? And I think the answer to that must clearly be no. The only body that had jurisdiction in any intelligent sense to answer that question must have been the Spanish court. And you get this in other areas of law, particularly public law all the time, where the judiciary in public law cases is adamant to say, well, the executive may well be master of its own domain when it comes to decisions of policy, finding the facts and so forth. But it's the courts who have the last word on what are the four corners of the executive's legal powers. And I think in this unusual situation, that's the position here. Well, I hope that clarifies.
Yeah.
He may well have had the power to make a determination on that question, but it is not the final power because it's subject to the supervision of the courts and being overturned on a jurisdictional challenge. And that potentially the consequence of this line of thinking is that a determination of that nature by an arbitrator, if it's splitting out competence such that the principle is applicable to certain jurisdictional questions but not others, or it's saying that a particular type of decision is not actually a jurisdictional decision in the first place, in which case, if a tribunal were to make it, nonetheless, that's not reviewable as a matter of jurisdiction, potentially. I'm not disagreeing with you. I'm just playing it out and thinking through the issues, because I agree that this case is very specific and not one that you're going to come up against very often.
No, you're right about that, and that's why I try to make the distinction in these terms, and I think I stick with this analysis. One question of authority, one species of question of an arbitrator's authority to exercise the power of the tribunal that can't be a question of jurisdiction, is the question of authority to determine the tribunal's jurisdiction. In other words, to exercise the power given to the tribunal by the competence doctrine. That clearly, that can't itself be the subject of competence, because that would be wholly circular. I'm absolutely fascinated by the really difficult philosophical and existential questions that this case arises, which is why I think possibly not just a master's, maybe a whole range of doctoral theses in due course. But I think the question just reflects the complexity, but also the attractiveness of finding simple solutions to difficult questions where we can.
Well, ladies and gentlemen, thank you very much for being a very wonderful audience. May I take this opportunity to thank my three panelists today. Thank Professor Catherine Rogers, who's speaking to us from Milan, Dr. Brendan Plant, and Mr. Gordon Nardell, all my very old and very dear friends. Thank you so much.
Wonderful day, everyone. Congratulations.
Can you hear me? Yes, thank you. Thank you very much to our panel of speakers and moderator for this insightful session. May I kindly request the panel to remain on stage. I now invite Dr. Punita Silivaraju, Deputy Director General in the Legal Affairs Division of the Prime Minister's Department of Malaysia, to present a token of appreciation to the panelists and to the moderator on behalf of the organizers. Thank you. Welcome back, ladies and gentlemen. We now move to the second session, titled Regulating Third-Party Funding in International Arbitration and a Review of the Recent Supreme Court Decision, R versus Competition Appeal Tribunal and Others, dated 26 July 2023. This session will be moderated by Mr. Hussein Hairi. Mr. Hussein Hairi is a partner in the London office of Withers. He is a co-head of the firm's International Arbitration Group and head of the firm's public international law team. He is a solicitor advocate of the senior courts of England and Wales and has extensive experience of working in international legal and dispute resolution matters in London, Paris, New York, and South Africa for almost 20 years. He is also a solicitor advocate of the Eastern Caribbean Supreme Court. In addition to his practice as counsel, Mr. Hussein Hairi sits as an arbitrator. He is a senior fellow at SOAS University of London and a member of the management committee at the SOAS Arbitration and Dispute Resolution Centre. Please join me in extending a warm welcome to our moderator and our esteemed panelists, Mr. Stephen Fieta and Ms. Camilla Godman, along with Professor Victoria Shannon Shahani, who will be joining us virtually. Thank you very much.
Thank you, Amal, very much. I will begin by giving short introductions for each of our three very eminent speakers, and very delighted to welcome them here for this discussion on third-party funding. So to begin with, we have Professor Victoria Sahani on the screen, dialing in remotely. She is a professor of law at Boston University School of Law. Among her many publications, she co-authored the book, Third-Party Funding in International Arbitration. She is chair of the Institute for Transnational Arbitration Academic Council, a member of the ICC Commission on Arbitration and ADR, and a member of the ICA Queen Mary Task Force on third-party funding in international arbitration, one of the many interesting developments to discuss today. To the left of the table is Mr. Stephen Fietta, King's Counsel, principal and founder of Fietta LLP. He is one of the world's leading practicing public international lawyers. He is top ranked in global and UK directories and has one of the world's most prolific and long-standing practices as counsel in both international investment arbitration and interstate disputes. Finally, Camilla Godman, to my left, is an investment manager and senior legal counsel at third-party litigation funder Omni Bridgeway. She is based in London, where she is responsible for originating, assessing, and managing funded cases internationally, with a focus on EMEA and the UK. Camilla is a cross-border disputes lawyer and a qualified arbitrator with over 20 years of experience. She was formerly Deputy Registrar at the Singapore International Arbitration Centre and a director of the Chartered Institute of Arbitrators, where she established their first office outside the UK in Asia. Throughout her career, Camilla has collaborated with leaders in the ADR field to develop regional and international ADR policy, notably in 2020 with UK ministers from the all-party parliamentary group for ADR, focusing on the UK's position as a leading disputes hub. So I'm delighted to welcome these three very eminent speakers for what I hope will be a very stimulating discussion on third-party funding. We have an hour for the initial discussion before we come on to questions. So we're going to break that down into 4 different sections of approximately 15 minutes each. And there'll be a number of questions posed on each of those topics for what I hope will be a relatively interactive discussion. The first section will deal with the overview of third-party funding. What is it? How does it work? And what have been some of the major developments in third-party funding in recent years, and indeed the last 15 years, since the field has really become established as a part of everyday arbitration and litigation practice, and increasingly since then. The second issue will be the Pakar decision of the Supreme Court that was mentioned. What are the legal issues that arise from it and consequences? The third will be taking stock of the state of play on regulation of third-party funding, including self-regulation as applies in this jurisdiction, and international legislative reforms pertaining to third-party funding in a number of different jurisdictions, including also potentially looking at some changes in terms of arbitral institution practice and rules. And the fourth will be looking forward into what the future holds for third-party funding, both in terms of practice developments, but also potentially in terms of legal changes. So to start on this first issue of an overview of third-party funding, some conceptual framework, and some notable developments, I'd like to ask first Victoria, please, to come in, including with reference as appropriate to your experience with the ICA Queen Mary third-party funding report.
Thank you, Hussein. Can everyone hear me? Okay, good. So thank you so much, Hussein, for that very kind introduction. And I would also like to thank the Asian International Arbitration Centre, SOAS University of London, Arbitration and Dispute Resolution Centre, the International Dispute Resolution Centre of London, and the Government of Malaysia for inviting me to speak, and also for organizing this conference. I am sorry I'm not able to be with you in person, as I'm juggling multiple commitments in multiple locations, but thank you for allowing me to join virtually. So I first wanted to quickly, as Hussein mentioned, talk about an introduction to third-party funding. And I think the first thing to do would be to define third-party funding, because everyone may think they know what it is, but may have different views about how it works. And so just to propose a quick working definition, in essence, third-party funding is when an entity that is neither a party to a case or to an arbitration, nor the party's legal counsel. And that's important because in some jurisdictions, lawyer or law firm financing exists where the lawyer or law firm provides funding to the client. That's not what we're talking about here. So neither the party nor their lawyer or law firm provides financial resources to enable a party to the arbitration to proceed. And that could be the claimant, it could be the respondent. And so that's a very, very basic, simple definition. And so third-party funders provide this funding typically for profit-making purposes, but not always. There are types of funding in which the funder might be seeking a certain outcome in the case, for example, to create a certain precedent or to get a certain interpretation of a treaty. There are also circumstances in which a party funds a case for political reasons or other reasons that don't relate to profit. So just to keep that in mind. But for the most part, we're usually talking about for-profit funders when we talk about third-party funding. So that's what I'll focus on for the rest of my remarks. So Hussein also mentioned the ICA Queen Mary Task Force. And so I'll just talk about that very briefly. ICA, the International Council for Commercial Arbitration, and Queen Mary University School of London, the School of Law there, together they collaborated to create a task force. And the task force existed from 2013 to 2018. So over 5 years, it worked to produce a report and annexes that were both published in April 2018 and presented at the ICA Congress that year. Those documents are available on ICA's website for free, so you can download the report and annexes. So what was the purpose of the task force? It was to study and examine third-party funding and its impact on international arbitration. And so that was the main focus. The task force looked at third-party funding across a wide variety of jurisdictions. It looked at the question of definitions, which I just gave you a simple definition. The definition question is actually much more complicated than that. And the task force looked at that question, as well as disclosure and conflicts of interest, privileges or evidentiary protection rules. So for example, attorney-client privilege, or in the United States, we have work product protection. These are ways to prevent disclosure of evidence to an opposing side. So we looked at how funding affects privileges, and then costs and security for costs, when that would be applicable in a funding context, principles of best practice, and also investor-state arbitration. And so all of those topics were put into the report, and that was sort of a snapshot from 2018 of what the world looked like. So I urge you to take a look at that report on their website. Again, it's free and anyone can download it. And so I'll just quickly mention that the main overview of the funding arbitration rules would basically be disclosure. If you look at arbitration rules today, many of them actually have included disclosure rules about funding. I won't go through them now, but if anyone has questions about them later, or maybe at some point later in this discussion, I can talk about a few examples. But that's the main way in which arbitration institutions are trying to learn more about funding. So disclosure usually includes the fact of funding, so a party having to volunteer the information that they are being funded, or maybe they are required depending on the arbitration rules, and then who the funder is. And the reason that you need the name of the funder is so that the arbitrator can check for conflicts of interest. Sometimes there can also be conflicts of interest with counsel to parties, but that's not often the case. And then the final reason why disclosure is important is cost. So sometimes cost allocation is affected by the involvement of third-party funding. And so when you know there's a third-party funder, there may be circumstances in which the arbitrator can ask for additional disclosure in order to assess the amount of costs, if there is going to be some cost shifting or cost awards. In the case of investor-state arbitration, occasionally there is a application for security for costs if the funder is involved in a circumstance in which the funded party is impecunious, meaning they don't have the money to pay, and the respondent, it's usually the claimant, the respondent is concerned that if the claimant loses the case, they won't be able to pay costs. and which is why they have a funder. And so the respondent might ask for security for costs. So that's another circumstance in which information about funding would have to be disclosed. So that's just a little bit of an overview, very quick. I'll stop there and look forward to the rest of the discussion. Thank you.
Thank you very much. And you've mentioned some of the rules that are addressing the issue of disclosure and third-party funding. I think the ICC, the recent ICC rules are one, the ICSID rules as well. And you see some trends in treaty practice as well, where some so-called new generation treaties address disclosure on third-party funding, like the Netherlands model investment treaty. So this is a very dynamic space, I think it's fair to say. Thank you, Victoria. So Camilla, looking at this from the perspective of practice, as it were, with the funders hat, how would you set out the framework for third-party funding, the processes? I think it would be useful to get a sense of the diligence and the way that you approach cases when they are raised for potential funding.
Thank you, Shane. Thanks, Victoria. And Victoria described it in just the right way. And I just wanted to add to her description of third-party funding that it's also non-recourse. So in the event that the funded case is unsuccessful, it's the funder who takes on the payment of the fees, and in many cases, the adverse cost payment as well, depending on the jurisdiction. Funding can be used at any stage in a proceedings, not just right at the start of the proceedings. If a claimant is finding that the case has become far more complex and complicated and the legal fees are racking up and they're running out of capital to pay the law fees, we'll look at funding a case at any stage, including the enforcement stage as well. So it's fundamentally a risk-sharing agreement, and it's documented by a litigation funding agreement. But the start of the process, we're usually approached by law firms, knowledgeable law firms who've advised their clients on the availability of third-party funding, and professional third-party funders out there will approach us. And what we're looking for is for the lawyers to really give us a true sense of the case, including the issues. So one of the first things we'll be looking at is the economics of the funding. If it's not one of the cases that Victoria describes where there's an alternative reason, most cases are commercial funding. So we're looking basically for a realistic quantum of the case to be about 10 times the project budget that the client is asking the funder to pay their lawyers. In that sense, if the success fee is, let's say, 2 or 3 times what the funder has put in, then the claimant will end up getting at least 70% of their resolution sum. I say that with the caveat that one of the new developments around this area, and as it becomes increasingly popular, is that claimants are being able to apply to tribunals to recover the costs of the funding themselves. So the defendant pays the arbitration costs and the funding costs. So all of the damages goes to the client. That is, a lot of tribunals are being approached to assess costs and award costs on that basis. And that circles back to the need to disclose the involvement of a third-party funder right at the start, so that an opponent knows they may face this risk of also having to pay the funder's costs. So the process, once we've spoken to the lawyers, looked at the merits of the case, assessed what we think the realistic quantum is. In many international arbitration cases, there may also be a jurisdiction argument, and investor treaty cases, there often are arguments about the wording of the treaty. So we will work with the lawyers and the claimants to assess the merits. Generally, with a finger in the air, we look for about 65% or more chances of success of the case. Objectively assessed, it's obviously a difficult thing to put your finger on. Once we issue draft terms pretty early on in a case so that the client can see the pricing and how the pricing is structured. There'll then maybe be some negotiation on that, and we'll enter into a term sheet, following which at Omni Bridgeway, we do all of our due diligence in-house. So we'll work with the lawyers to look at a lot of the papers, look at how they've assessed the case, look at any of the issues. If it all goes well, we approach our investment committee. Usually we hope to do that within about 4 weeks of signing the term sheet, depending on how developed the case is. And then once we've got it approved by the investment committee, we'll enter into an LFA and we can start paying the law firm's fees.
Thank you very much. So I think this brings us now to the second area for discussion, which is the PACAR decision of the Supreme Court at the end of July. This was a case that involved the Competition Appeal Tribunal. So what is the relevance legally from it that applies more broadly to third-party funding in this jurisdiction? Stephen, could you set out the main background to that case and the legal issues as you see them?
Sure. Thank you, Hussein, and thank you again to the organisers for inviting me to this very topical and important event to address this very topical and important decision of the UK Supreme Court. So, by way of context, the historically, agreements by which lawyers or funders were entitled to share in clients' damages recoveries in English litigation were prohibited under common law. That was on public policy grounds, and the relevant body of doctrine was that of champity, these agreements whereby third parties would benefit from the litigation of a victim, so to speak, was seen as champitous. But that common law position, which I think is a cornerstone of many common law jurisdictions, evolved somewhat and quite quickly and somewhat haphazardly following the arrival, among other impacts, following the arrival of third-party litigation in England about 15 years ago, at least on a large scale. There was a decision called the Arkin case back in 2005, which was a seminal decision in the development of the common law in this area. And that found that a funding agreement would be enforceable so long as a claimant was left in control of the litigation. In other words, so long as the funder took a passive role in the litigation and did not take over management of the litigation, the common law at that time was not so interested in other aspects of a third-party funding agreement, and therefore it would not be seen as champitous. But on the back of that evolution in the case law, and the back of a booming third-party litigation market, various reviews were undertaken in the United Kingdom into the regulation of third-party funding and other things. And the Jackson, Lord Justice Jackson review was particularly important in that context. And on the back of that review, a series of legislation was passed regulating so-called damages-based agreements. And they included agreements that provided for claims management services by third parties. And these definitions of damages-based agreements and claims management services became very important, because if an agreement met these definitions, and in particular in this context, if the funder was offering claims management services, then they would come into the remit of the legislation and regulations, and they would have to meet various important requirements under English law as it was then evolving. And the PACAR case really came out as an important decision in the analysis of the application of these new rules and the statutory definitions in particular to the sort of third-party funding that we're talking about. The case, as Hussein mentioned, the underlying case was before the UK Competition Appeal Tribunal. It concerned an allegedly unlawful and anti-competitive truck manufacturing agreement. The claimants in that case were claiming compensation for inflated prices and obtained third-party funding from, among others, an entity called Therium, funny enough, who are also, as we heard from the Minister, earlier involved in the Sulu case. The issue before the Supreme Court was whether the funding agreements in the case were lawful under English law, because in order to proceed in their claim before the UK Competition Appeal Tribunal, the claimants had to show that they had lawful and reliable funding for their case. Of course, the claimants claimed that their funding was lawful. Their main point was that their funders were not taking an active role in the litigation. They were not managing the case, and therefore the claimants argued that their funders were not providing claims management services for the purposes of the litigation. The respondents argued that these were claims management services because within the definition of the statute, the funders were providing, quote, financial services or assistance in relation to the making of a claim, close quote. Now, the Supreme Court applied what I would say is a classic black letter reading of the statute, which it said, and as a result of which it found that the financial services being offered by Ethereum and the other funder in the case clearly did constitute claims management services within that definition, which I just read out. They said, the court said there was no other plausible way of reading the definition. As a result of the finding of the court, the agreements that were funding the case were rendered unlawful and unenforceable. In fact, that was common ground between the parties because even the funders, I think, acknowledged that if this agreement were to be found a damages-based agreement under English law, it would fall foul of the relevant regulations, which include caps on recovery for funders and other things. So what are the consequences? Well, briefly, the court itself recognized that its finding meant that most third-party funding agreements in England and Wales were rendered likely unenforceable. In particular, those where the funder remuneration had been calculated by reference to a percentage or proportion of damages that would be recovered in the litigation. As we'll hear later on, there are other types of funding agreement which perhaps are not caught by the decision, where the recovery of the funder is not based on a percentage or proportion of damages. The impacts perhaps at least expected at the time on third-party funding in the UK are perhaps best articulated by reference to the witness statement given by Susan Dunn, who is the chair of the Association of Litigation Funders in the UK. She gave a witness statement in the PACAR case. She testified that a decision finding the agreement unlawful could, open quote, bring to an abrupt end hundreds of funded claims with potentially catastrophic financial consequences for all involved, close quote. Now, it's notable that since then, other funders have wound back a little on that assessment of the implications of the decision, emphasizing that a number of their agreements are not based on percentage recoveries or can easily be renegotiated. But clearly, the PACAR decision had a fundamental impact. The Department for Business and Trade has stepped in and commented in a typical civil service Mandarin kind of way that, quote, the department is aware of the Supreme Court decision in PACAR and is looking at all available options to bring clarity to all interested parties, close quote. So no doubt in the background, there's now a frenzy of representations being made to the Department for Business and Trade as to how this clarity might emerge from a decision that has certainly upturned the apple cart in third-party funding, at least in the UK.
Thank you very much. Camilla, would you like to come in on that with your perspective on it?
Yeah, thank you. I think it's important to say from the outset that this decision is not actually a criticism of the litigation funding industry. And I think it's actually an example of the law of unintended consequences where wrong definitions from one statute have been incorporated into another. And the Association of Litigation Funders, of which Stephen just spoke about, and our chair is Susan Dunn, are working with the Ministry of Justice to try and work out a solution. I think it has the greatest impact in relation to competition claims in front of the CAT, such as PACAR, and I think there may actually be some sort of remedial legislative action in relation to that potentially before the end of the year. The DBA regulations themselves were always due to be changed and seem to have got quite low down the priority list. So as the funding industry is hoping that may be pushed up the funding list, but whether it's in this government or the next, I'm concerned it may be the next. So as funders, how we've reacted, well, I think there are 4 practical takeaway points. The commission structure in litigation funding agreements are typically, before PACAR, the higher of either a multiple of the funded costs or a percentage of the resolution sum. In some cases, it may be additional, a percentage of the resolution sum and a multiple of the funded costs. The consequence of PACAR is that we may need to change our LFAs potentially to multiple only in order to avoid litigation funding agreements being damage-based agreements. The alternative structure, which is slightly more tricky and the funding industry is still a little bit on the shelf on it, is to try and structure the LFA so it comes outside, it becomes a compliant damage-based agreement, and it complies with the requirements of the DBA regulations. In the short term, I think it may affect the type of claims that that funders will claim. It may make the market more competitive. We may apply even harder rules in order to assess cases. But I think in particular, we're looking for those cases where the multiple only will bring a similar outcome to a percentage. Those cases where you have the funder is taking on a large risk with a potential upside that a tribunal or a court may order a large amount of damages, and therefore the upside of taking the higher of a percentage is now essentially stripped away. So you may be looking more at cases where the quantum is more reasonable. And actually, in that sense, then funders won't be interrogating the quantum so much as potentially previously they have, because as long as there is enough likely in the pot to be a multiple of their funded costs, then any increase in the quantum won't concern a funder. Most litigation funding agreements already have a severability clause, which severability clause would allow for an unenforceable or void clause in the contract to be severed from the rest of the contract. I think there is some doubt that because the DBA regulations and the result of the PACAR goes to the root of the litigation funding agreement and the commission structure, that being able to strip out the offending clause essentially renders the agreement useless. So severability clauses are going to be a little bit more difficult to rely on, I think. And lastly, another potential avenue to troubleshoot the PACAR decision would be to change the governing law so that the offending DBA regulations don't apply at all. In many cases, that's possible. In a lot of the international arbitration cases, that's possible. However, in cases where there is nothing but the nexus to English law, it's English High Court, and trying to move it to another jurisdiction just looks like a bit of a ruse. Then it's going to be a more difficult red flag for a judge to point to us suddenly changing the governing law. So yeah, for the moment, I think it's changing to multiple only or taking it to be a compliant DBA.
Thank you very much. So this, I think, brings us on neatly, perhaps, to the issue of regulation. I think it's important to perhaps go back a little by way of context on third-party funding and its self-regulated standing, at least in this jurisdiction. And it comes back to really the issue of access to justice and the statement made by the Irish judge, Sir James Matthew, that justice is open to all, just like the Ritz Hotel. And of course, we know that litigation, arbitration can be expensive. And so there are some real practical impediments towards access to justice, particularly at a time and in a context where public funding for litigation is decreasing, certainly in this jurisdiction. So that was the context for the review of civil costs by Sir Rupert Jackson back in 2009 and his report, which provided in turn also momentum for the establishment 2 years later in 2011 of the Association of Litigation Funders and a self-regulated regime, which has certain requirements for members, including capital adequacy and a complaints procedure. Fast forward from that to today, and there are some quite significant developments around potential regulation of third-party funding. The Voss report at the EU level is one, and there have been a number of legislative changes in jurisdictions such as Singapore and Hong Kong, now also potentially Ireland, to allow for third-party funding, at least for international arbitrations. So considering this quite dynamic regulatory framework internationally, I'd like Victoria to bring you back in to provide your thoughts on how you see developments in this space of regulation or self-regulation.
Thank you, Hussein. You know, as you just mentioned, the regulatory landscape for third-party funding across the world is rapidly changing. So even as I'm speaking to you, what I'm telling you is probably becoming obsolete. But I urge you in your home jurisdictions, before you engage in funding or look into funding, to check. And there's a lot of sources that you can check for figuring out what the funding regulatory landscape is. And I'll name just a few. I think there is at least 7 different ways, or at least 7 different ways of regulating third-party funding that exist across the world. And I've discovered these ways through my research for my book, Third-Party Funding in International Arbitration. Looks at over 60 jurisdictions around the world. At that time, it was 2017 when we published the 2nd edition. Now there are even more jurisdictions that have regulated funding. But we sort of grouped, I sort of grouped them into categories. So here are sort of 7 different ways, and I'll give you a couple of examples in each category. One way is court oversight. And this is I think the most common way across the world. In many jurisdictions, the first time they even notice funding is because it shows up in a case, often a domestic case, but sometimes it's an international arbitration case. And in any event, that situation is brought before court, and the court has to figure out what to say about funding based upon whatever laws exist in that jurisdiction. And so court oversight is the oldest and the most common means of regulating the funding industry. There are many famous cases from around the world. For example, in Australia, there was the Campbell's Cash and Carry versus Fostiff case, which legalized funding in Australia. There's been several cases in the United States. In the United States, funding is regulated state by state. So you would get the state Supreme Court in a particular state in the US opining about funding. In the UK, we have SR versus Norscut, which is another case that talked about shifting funding costs or allowing a funded party to recover their costs from the opposing side, which is unusual. In that circumstance, the court had found that the party that lost the case had created a circumstance in which the funded party had to seek funding. So those are just a couple of examples of court oversight. The second way, which we've talked about a little bit earlier when Stephen and Camilla and Hussein talked about this in the UK, it's the funder self-governance. So the Association of Litigation Funders is a prime example across the world of funder self-governance. There have now been other organizations that have popped up. So for example, there's the International Legal Finance Association, it's based in Washington, but it's internationally focused. There's also the American Legal Finance Association, which is based in the US, just as a couple of examples. Also, some funders actually have internal codes of conduct. Some of these funders post them on their website, others do not. But those are some other sources of this funder self-governance method of regulation. Then there's attorney regulation. So every funder involved in a case has to deal with an attorney. The client has an attorney. The funder does not represent the client. That's key to the definition of funding. And so through attorney regulation, which every jurisdiction that has attorneys regulates them, there are ethics rules, there are other standards and requirements for attorneys through which funding actually gets affected. So as an example, the attorney-client relationship is considered to be a protected relationship in pretty much every jurisdiction I've looked at. And so any potential for funder interference in the attorney-client relationship would be something where the attorney regulation would actually push against funder involvement, or at least require the attorney to set up certain types of protections or requirements. In addition, attorneys are supposed to have professional independence from the funder. So even though the funder is paying for the case, it doesn't mean they get to instruct the lawyers. The client is still the one to instruct the lawyers. And in this circumstance, I'm talking about a classic non-recourse, independent, arm's length third-party funding. There's a lot of other types of third-party funding where the funder might actually exercise some control if there's equity or something like that. But in the classic funding case, the funder is supposed to remain at arm's length. And so attorney regulation would tell the attorney that if the funder is interfering too much, that the attorney might need to take certain actions in the case. This is also sort of influenced by the fact that in some jurisdictions, funders can actually own law firms as partial owners or even complete owners. And so that does make it a little more fuzzy. But attorney regulation, again, is the third way. The fourth way is the financial services industry. So in some jurisdictions, funding is considered a form of financial services, and every country has some sort of financial services regulation. And so that regulation then would apply to the funder. So for example, in Australia, there's a requirement that funders obtain an Australian financial services license, and they can be regulated by the authority that governs financial services in Australia. In the UK, the Financial Conduct Authority regulates funders' asset management activities. In the United States, the Securities and Exchange Commission regulates publicly traded funders and also in some circumstances, private offerings. So if funders securitize litigation costs and sell derivative interests in lawsuits, which is potentially possible, then that would also fall within the financial services industry regulation. So usually this is for much larger funders, more sophisticated funders, but it can apply to smaller funders as well. And then we have statutory regimes with government enforcement. So Hong Kong and Singapore, as Hussein mentioned, are two jurisdictions where third-party funding has been legalized by statute with certain limitations. And then that statute is enforced by the government. There are also several US states that have statutes that allow third-party funding and regulate it. The Voss report, which was just mentioned, is essentially a draft proposed regulation document from the European Parliament Committee on Legal Affairs. And the idea there would be to implement some sort of statute or regulations there that would then be enforced at the governmental level. There has been some talk about potentially a model statute or model law for funding that hasn't yet emerged, but I'm curious to see whether that might come about in the future. And then non-governmental and multinational approaches are also very common. So for example, I already mentioned the report of the ICA Queen Mary Task Force, so global task forces. There's also UNCITRAL working groups 2 and 3 have also looked at third-party funding, particularly working group 3 on investor state dispute settlement. The Singapore International Arbitration Centre and also the ICC have issued guidance. This is not a rule, but guidance to arbitrators encountering third-party funding in a case ICC also has a rule now, but in the past, they only had guidance. And then another example, just to throw out one more, is the Brazil's Center for Arbitration and Mediation of the Chamber of Commerce of Brazil, Canada. So this is commonly known as CAM, CCBC. You might have seen that acronym. That's an arbitration institution in Brazil. They don't have an arbitral rule, but they do have a guidance that requires parties to disclose their funding. So those are some examples of non-governmental and multinational approaches. And then finally, the funded client's contract. So the actual contractual terms of the funding agreement do govern funder conduct. And so it's very important when thinking about funding or engaging in funding that as a funded party or as a attorney representing a funded party, you pay close attention to the terms in the contract and ensure that the funder abides by them. So those are 7 different ways. And then there's the 8th way, which is no regulation. And in much of the world, there is no regulation of third-party funding yet, either because funding is not that prevalent or because the governmental entities have not yet decided whether to engage in regulating funding. So those are some, it's a sort of a quick overview of the state of play of regulation and third-party funding. Thanks very much.
Thank you very much for that overview. I think also interesting to keep in mind in that latter category of jurisdictions that neither expressly allow for nor prohibit third-party funding, important jurisdictions like China and India, where decisions of courts in recent years have been seen to be broadly supportive of the possibility of third-party funding, albeit they don't have strict binding precedent as we do in this jurisdiction. But nevertheless, that's quite an instructive development given the size of those disputes markets potentially. So Stephen, can I bring you in on the regulation aspects, how you see them?
Yeah, sure. I think it's important to point out, first of all, that although there's a broad range of debate over the extent that, that this sector should be regulated, the form and content of the regulations, no one is talking about outlawing third-party funding. Everyone recognizes that it has a role to play in a modern justice system. What I think all of those looking at regulation are trying to achieve is a balance. And as Datu Sri Azalina, the Honourable Minister, pointed out in her opening remarks, she described it as a balance between access to justice, including by the impecunious, of course, and the integrity of the justice system. And there's different ways in which that balance might be struck. Now, historically, up until now in most jurisdictions, to the extent there's been much regulation, it has been by way of soft law provisions, such as in the UK, you've had the Code of Conduct for litigation funders, etc. And in some jurisdictions, therefore, the debate is over whether or not there should be a move to hard law requirements, hard law regulation with firmer sanctions for violation, or not, or whether this industry should be left to be self-funded or self-regulated. I think another key point to make is that the large responsible funders, such as Omni, are in favor of looking at ways of regulating this activity so as to wean out the cowboy funders. I mean, there has been a history in this field of some funders who are less scrupulous than others. I was involved in a case where we had an impecunious client who needed funding, and his funder committed to fund the case, but didn't disclose how it was going to fund the case, and ran out of money halfway through, leaving everybody up the creek without a paddle, including the claimant, of course, including the tribunal was left at a bit of a loss as to what to do. It didn't want to abandon the case through an eventuality that was utterly outside of the parties and the claimant's control. And ultimately what had to happen was there was a very long suspension of the proceeding while the claimant went out to procure a replacement funder, which not only caused significant delay, but in substantial additional expense for the funded party. So there's certainly an interest out there, a public interest in the regulation of these sorts of activities, I think. It's a question of the extent to which that regulation is made hard law and the contents of it. I think the EU, my last point, has been relatively late to the party, partly because there haven't been a lot of funders based in the European Union, especially since Brexit, because I think most of the funding within Europe takes place through the UK. But belatedly, they are looking very hard at hard funding, hard law funding. And this Voss report, which you mentioned, Hussein, Voss is a German member of the European Parliament who was tasked with looking at this closely. It takes quite a strong line on the regulation of third-party funding, proposing harmonized funding across the European Union by way of a directive that would cover lots of different aspects, such as a requirement to be authorized and registered as a funder, which of course will require certain thresholds for the funder, capital adequacy requirements to ensure that funders weren't going to run out of money and were in a responsible position to fund the case from beginning to the end, fiduciary relationship towards claimants, disclosure of third-party funding agreements, which is really important. Transparency is another thing the Minister alluded to earlier. There's a lack of transparency or perceived lack of transparency around much of this. The EU proposal is that there will be an obligation legally to disclose agreements to the court. Strong safeguards against conflicts of interest, a cap on fees for funders. I think the cap being talked about is around 40%, or a general rule that can be waived in exceptional circumstances, that a claimant should recover at least 60% of damages. And finally, a prohibition of taking control over the proceedings, which of course is already part of the English common law, for example. So if the EU, I think there's a draft directive, if that is implemented, of course it will become binding on all member states. That will make quite a significant inroad into third-party funding regulation. It would be very interesting to see whether others follow suit. And if they don't, whether there's a move of some funders who are currently based in the EU out of the EU to avoid that sort of regulation.
I think it's fair to say there has been quite material engagement by the third-party funding industry on this proposal by the EU Parliament of adopting the Voss report to the European Commission. ILFA, for example, I understand, sent a letter to the Commission in response to that report. I don't know, Camilla, if there's anything that you would say from your perspective and experience on this.
Yeah. So Stephen's right. I think there is certain aspects of the sort of regulation being called for, particularly in Europe, that Omni welcomes. There has been in the market in the last 10 years, non-professional funders seeking to cash in and not really understanding what they're doing, and not having enough capital to be able to see the cases through and leaving claimants high and dry. So the strong recommendation, even if someone is approaching Omni or not, is to look at funders' capitalisation to ensure that they do have the means to see your case all the way through, and look at their track record to see the sort of cases that they're funding and whether they're picking the winning ones. So yes, get independent advice from the lawyers, but also separately, if the law firm themselves are also going to be involved, or if there is going to be some security taken over the claim by the funder that isn't in a jurisdiction that the claimant is familiar with, or that their current lawyers are familiar with, they should also seek to get independent advice around that as well. So yes, so certain of the recommendations we do welcome. Hussein's absolutely right. The International Legal Finance Association, of which Omni is also a member, put in a response to the Voss report. Certain of the Voss report's recommendations we think go too far. We're all for a system of authorization and minimal capitalization, and certain things completely misunderstand how the funding industry works. The Voss report didn't involve any consultation with stakeholders, which is a lot of the problems with it, we think. So, for example, with disclosure, and they're mandating disclosure, but there are certain circumstances where disclosure can lead to unnecessary security for costs applications, and that it may be important to, in court litigation, to keep it secret. However, I should say that Omni, in all arbitration cases, operates a policy to make disclosure and very early on in the cases, so that if arbitrators are appointed who have a conflict with Omni in particular, that can be opened up and aired right at the start of the litigation and doesn't waste costs. Interestingly, the Arbitration Act in the UK has just been reformed, and the Law Commission in the UK has decided not to take any action in relation to the regulation of third-party funding. And they, which is what we hoped FOSS would have done, have said they will leave it to the relevant stakeholders to come up with a decision whether regulation is needed or not. So we appreciate that. And I think the last thing to say about the VOS report is caution about taking a one-size-fits-all. We haven't really talked today about the difference between civil law jurisdictions and common law jurisdictions. Third-party funding has really grown out of common law jurisdictions. It started in Australia, came to the UK, but it was also, has always been permitted in civil law jurisdictions under the basic principles of freedom of contract. And so putting restrictions on third-party funding in these civil law jurisdictions imposes restrictions on that basic freedom to contract. So needs to be looked at very cautiously towards one size fits all across Europe, we think.
Thank you very much. So that leads us to our fourth and final area for discussion, which is what does the future hold for third-party funding? Clearly, from a commercial perspective, the industry has grown very significantly. A major global insurer estimate that there's about a market value of $17 billion or so in third-party funding now. One of the major funders estimates that there's a growth of about 8% a year in terms of third-party funded cases. And Ernst & Young did a survey just after the pandemic, suggesting that the respondents indicated that although about 25% had said that they might have considered third-party funding pre-pandemic, more than 50% considered that they might use third-party funding post-pandemic, considering constraints on working capital, which have all been rendered the more acute in recent and subsequent years with the global inflationary situation such as it is. So I think regarding some of these potential prospects, as well as some changes in practice going forward for third-party funding, Camilla, can I bring you back in firstly for the last comments from each of the speakers?
So yeah, what does the future hold for third-party funding? I think there are four main points that I would make here. We're often asked, do we fund defences? I think as funders get more sophisticated, they are finding ways to fund defences. We certainly have a few cases where we've come up with some creative ways to fund defences. An obvious way is where we fund portfolios of claims, and there's cross-collateralization within those portfolios of claims, so we can fund defences at the same time as funding claims. And another way is where you link the idea of success, not necessarily to the outcome of the claim itself, but maybe just to a positive award in jurisdiction, and the claimant chooses to pay the funder in a different way. So I think there will be more creative products, more areas of law which amend themselves to funding. IP is becoming a more popular way, subject to fund. And fraud cases are also increasing in funding. I think there will be some improved certainty from arbitral tribunals and from courts around recovering the costs of third-party funding, which is something that I spoke at the beginning, and Victoria also acknowledged this case of SR and Norscott. But I think it won't just be in cases where the respondent has acted particularly badly. I think it'll be opened up. I think we've talked about non-professional funders and professional funders. I think the non-professional funders will be driven out of the market by professional funders, if not by regulation, then by the professional funders themselves and by the cases that they lose and unfortunately can't stay in business. And lastly, sort of as the market develops, one of the interesting things becomes a secondary market. So we're now finding that funders themselves begin to risk share in their own cases, particularly in investment treaty cases where investors in our funds are a little bit nervous around cases that go on sometimes as long as 8 years. And so if after 4 or 5 years of the case, funders can risk share and put it on the secondary market and other funders pick up some of that risk. I think we'll see that more and more.
Stephen, and your perspectives on the future and what it may hold.
Thank you. I certainly agree with much of Camilla's comments just now, all of them, in fact. I think we will see greater regulation, clearly in one form or another, of third-party funding. That may be quite different across different jurisdictions. And that in turn may lead to market changes in third-party funding and even the physical location and jurisdictions out of which third-party funding takes place, particularly in connection with international litigation and international arbitration, where of course funders are fluid and can move and can change their applicable laws for their agreements relatively easily in order to adapt to regulatory pressures. I think as part of that, there will be more transparency around third-party funding. We've seen quite a lot of movement on that front in international arbitration and arbitration rules changing, as you alluded to, Hussein. Most of those rules currently require limited transparency. They don't require full transparency and disclosure of agreements, but they do require at least disclosure of key details around those agreements, such as who are the parties and the extent to which the funding covers adverse costs, for example, in the event of an adverse costs award against the funded party. So we will see more responsibilities and obligations generally, I think, for international funders. I think as part of that, you will see more diligence by international funders. They've already undertake, as we've heard from Camilla, substantial diligence into claims that they're going to fund. It may be that the diligence itself doesn't change, but the thresholds for a fundable claim may change. That 65% magic number may change, or other aspects that there may be pressures on lawyers to reduce their costs or otherwise, which is obviously the main cost that a funder will face. I agree with what you said about the kind of consolidation around the more responsible funders. I think I call them cowboy funders, but I think there'll be less and less of those. I think there already are. And I think as a result of that, there should be less frivolous claims, frivolous funded claims. And coming back to the subject or the background to today's event and what the minister called the Sulu fraud, I think there certainly will be, regardless of your views on that, there will be less frivolous claims as a result of greater regulation in this sector.
Thank you. And,
Thank you. I wanted to echo everything that Camilla and Stephen just mentioned. Respondent side funding is a huge untapped market. So whoever figures out, how to build a better mousetrap, so to speak, for that industry will really, it'll really blow up there. Equity funding, Camilla mentioned IP. That's one example where that happens a lot. Patent cases, if you have a company that has a very valuable patent and they're trying to get a determination of validity, often the funder taking equity in the client actually is worth more than the claim itself. And so they'll take an equity stake. And then, so I think that we're going to see more equity funding. Funders of funders, I think, is another thing we're going to see. Camilla mentioned risk sharing in secondary markets. I think that is some way in which funders offload some of their risk. An example of a funder that invests in other funders I've seen is Fortress. You might not have heard of that one, but they invest in other funders. And so I think we're going to see more of that, including lawyers investing in funders, which is something that is at least legal in the United States. Stephen mentioned regulation and increasing due diligence. I think that's crucial. Everybody's seeking funding now. I mean, parties now are aware of it, and lawyers are aware of it. And so there's a lot of cases that could be frivolous for which funding is sought, and the funders have to have a really good filter. And so I think due diligence is going to be crucial. And Stephen also mentioned cost reduction. I think cost reduction through price competition, funder to funder, but also attorneys bringing down their fees, as Stephen mentioned, I think is going to be crucial. And then a couple of other trends I've seen that I think will grow: not-for-profit funding. I think there's going to be a lot more entities that want to fund cases because they're seeking a certain outcome, particularly in the investor-state context, as well as in the state-to-state arbitration context, potentially. Crowdfunding, so a lot of small individuals pooling their money together to fund a case for a particular result. And funders stepping in and buying whole cases where the original party then steps away and the funder actually proceeds with the dispute as if it is the party. I think that's going to happen more too. And then a general trend for award publication, sanitized of course, but award publication and arbitration, I think that's going to assist the development of regulation of third-party funding as much as it will assist in the development of the regulation of arbitration practice. So those are just a few thoughts and trends I see for the future. Thank you.
Very much. And I'd really like to thank all of the speakers for what have been very, very rich comments over the course of an hour. We have got just under half an hour for questions. So let's please open it up to the floor. Anyone has any questions for any of the speakers?
Thank you. Hi, my name is Isam. I just have no, actually I have two questions, one of which is for Camilla and the other is for Victoria. You mentioned where third-party funders might want a certain outcome out of funding a litigation or arbitration case, and in this case they don't get recourse, they get equity in the claimant's company. But wouldn't that contradict the definition Victoria gave, where it's neither the party nor the party's counsel, where indirectly the third-party funder becomes the party itself, where they actually took part in the company's equity?
I'll let Victoria speak about taking equity. We don't look to take equity in the cases. That's not something that Omni does. When we fund defences, when I say that we may take security over one of their company's assets in order for them to pay us, but we wouldn't take equity in their company.
Okay, so before Victoria answers that question, sorry, would you ever face a difficulty if, because as you said, civil law jurisdictions don't actually pay much attention to third-party funding based on the principle of freedom to contract. So if you had a third-party funding agreement in a civil law jurisdiction for a litigation which is in a civil law jurisdiction, but where you're enforcing that agreement, where you want to take security over assets or enforce it over assets, is in a common law jurisdiction, where the third-party funding agreement is still not, still debatable. Might you find a challenge in enforcing that agreement in that common law jurisdiction?
That's something we look at very carefully in the course of our due diligence, that exact point. We would look at where we would want to. So I didn't mention earlier that one of the very important things we look at our due diligence stage is the chances of recovery against the counterparty. So we'll look at where that counterparty has assets. We'll almost always assume they won't willingly pay against the award. So we will look at where they have assets, where the defendant has assets, and we may need to take early on in the litigation or arbitration some sort of injunction in order to a freezing order against those assets. So if there is a risk that it's going to be difficult for us to get that security, then we will, because of the laws in that country, that will be something we take into account when we assess the risk.
So thank you for your question. So you're absolutely right that the example that I gave does not fall neatly within the definition I gave. And as I mentioned, my definition was a working definition. If you read in the ICA Queen Mary Task Force report, the definitions chapter, you'll understand and read about all the complications in coming up with the definition. So basically any definition of funding that you try to articulate will be under-inclusive and over-inclusive at the same time. So for example, insurance companies sometimes get pulled in under broad definitions. And my example where I just talked about equity, then the funder might actually be part of the party. So you're right, it doesn't fall within my definition. It's interesting. I think that it's becoming more common in certain contexts. I mentioned the patent context. Another example is that there was a case called Crystalex. It's a little older now, but it was a case in which you had a company going bankrupt and it had a claim against, I believe it was Venezuela. And it sold shares as its way of trying to fund its dispute. I don't think that most funders engage in equity funding as a matter of course, but it does happen from time to time. And many funders out there create bespoke agreements for funding where there may be funding structures out there that, you know, I may not even have seen yet because there's been no public examples given. There's also special purpose vehicles, which is where the claim gets assigned to an entity that's created specifically for the purpose of proceeding through the dispute. So the funder would have an equity stake in that special purpose vehicle as well as the client, instead of taking equity in the client itself. So there's just a lot of different ways that this can manifest. But you're absolutely right to catch that was slightly outside of my definition. Thank you.
Next question. Yes, please. Gentleman at the back.
Hi. Given that, all right. Hello. Sorry about that. Given that there's willingness on all sides to get the legislation fixed around this after the PACAR judgment, what sort of timeline do you see for the legislative process readdressing the question of claims management services, and how quickly do you think that could happen?
This is a reference to the somewhat non-detailed response from the Department for Business, but I wonder if, Camilla, you might have some thoughts possibly on this.
I think there is something that is hopefully in relation to competition claims against the CAT at least, because there are litigation funding agreements out there for such competition claims that are unenforceable, and it leaves claimants high and dry at the moment. Then I think there will be some legislation addressing that. I've been told potentially before the end of the year, slipping into another piece of legislation. In terms of going beyond that for all High Court English cases that are affected by PACAR, I think I know that there is a barrister who's very eminent in this area who has drafted something, but I am not hopeful that it's going to be within this government. But maybe I'm pessimistic. I don't think it's going to be their priority. Knowing how far, having worked and lived in Singapore and Asia for 13 years and seen how fast they've been able to get legislation through, unfortunately, we're not so speedy here. Stephen?
Yeah, I'd certainly have no insights into that situation. I guess I'd be interested in Victoria's insights, if any, as to the comparative urgency with which this issue is being looked at across different jurisdictions. I know that Australia picked up the baton relatively early and looked at regulation, albeit their regulation ultimately didn't, as I understand it, have that much teeth. But are some jurisdictions looking at this more urgently than others? I don't sense any urgency in the UK other than on behalf of the funders who might be wanting clarity.
Yes, Stephen, I think you're right. I think that governments move with all deliberate speed, so to speak, meaning that they don't move quickly. I actually think that's wise. Many of the regulators that are looking at funding don't know that much about it. They're still in the process of educating themselves. The Voss report, as Stephen and Camilla mentioned earlier, is indicative of how regulators may have a certain perception of funding that may not be completely accurate. And so I would hope that they would proceed cautiously, and therefore that might mean a little slowly, to make sure that they are addressing the regulations appropriately in the circumstances. To give an example from across the other side of the Atlantic, the US government had a couple of senators that were looking into this question. They tasked the Government Accountability Office with looking into the third-party funding industry and creating a report. So you can actually download that report online. It came out at the end of 2022, looking at the market trends. I think that eventually the US federal government might decide to regulate, but I don't think it's going to happen anytime soon for political reasons, but also because I think most legislators and regulators have a lot of things to focus on, as Camilla mentioned, a lot of other pressing matters, as well as they don't have the time to fully educate themselves as far as they would need to in order to create and draft appropriate regulations.
Can I make one further point occurred to me while Victoria was speaking? One area where I think we have seen a faster pace of regulation is where the states themselves have an interest. Of course, they may not have such an interest in your PACA type dispute, but of course they do have an interest in sovereign disputes and treaty disputes. And we have seen quite fast moving changes within the international arbitration world around aspects of third-party funding regulation, requirements for certain elements of transparency, safeguards for security for costs and those sort of things in funded cases. So it's been quite interesting to see actually that where the sovereigns have an interest, the sovereigns can make things happen quicker perhaps than will happen for the PACA style litigation.
If I may just jump in very quickly to add on to what Stephen just said, pay attention to UNCITRAL Working Group 3. They are looking at funding. They're going to be putting out guidelines and regulations probably pretty soon. So I would keep an eye on them if you're looking for fast moving sovereign interests. That would be where I'd watch.
Thank you very much. Yes, please. Yes, please.
Ben Rigby from the Global Legal Prep. Although one swallow should not a summer make, surely the implications of some of the things we've discussed from today in relation to the Sulu case call for some form of parliamentary discussion as to the issues raised, just as we've been discussing them here today. I wonder what the panel feels about that.
I mean, there's perhaps some overlap with the discussion around states' motivations and the sense of relevant urgency in respective jurisdictions. I wonder, Stephen, do you have any comments on that in terms of parliamentary discussion on this important issue and case?
I would agree. I think there are a number of issues here that go to public interest for sure, and public policy. And that's the backdrop of the common law rules that we're talking about. So given that, I think some form of public debate through perhaps a parliamentary question or something could only add to the discussion.
I think the gentleman here had a question.
More in nature of comment. Dato' Sundra just mentioned, and it reminded me in July, AIAC hosted a special seminar where Nevillian and Teresa Ting took part, and I was honored to be in a panel. The Sulu claim and the involvement of third-party litigation funding highlighted acutely for Malaysia the importance of regulating, or at least giving attention to this area. For a long time, Malaysia, like many post-colonial countries, suffered under champati maintenance, which are all part of a very good rules in the Victorian times. We all know that market society has now driven this issue to the fore. And it's not whether we should have regulations, it's why not and when, and in what nature a state should take attention to this. On this respect, since I'm holding the mic, I could respectfully request the Attorney General's Chambers and the Bahagian Halal Undang-Undang to bring to the fore this issue so that it can be discussed with transparency and accountability. And this maybe something good will come out of this because of the Sulu claim and the third-party funder. Whatever adjectives we want to put to these parties, it is important that this matter now need to be ventilated and augmented with proper attention. Thank you.
I think, and just to summarize, I think it's fair to say that the trajectory is towards greater degree of regulatory intervention. I mean, if one looks back in this country to the abolition of the torts and crimes of champati and maintenance, it's in 1967 that that's the case, subject to a quite narrow public policy exception where there's control or otherwise. But when you look at more recent developments, legislation in, well, Hong Kong and Singapore, for example, there is a greater degree of regulatory involvement in terms of disclosure of certain parameters and so on. So I think it's fair to say there is more broadly some trajectory towards the point you're making around regulation, and many funders welcome that in terms of having a kind of framework that's clear on the rules of the road. The scope and precise parameters of regulation, that may be subject to another probably conference day in its own right. But we do have a little bit more time for some further questions if there are any. Any more questions from the audience? Well, we've covered a huge amount of ground in the post-lunch slot, and I think you'll all agree with me that the speakers have been tremendous in their insights and the benefit for all of us of their experiences. So please join me in thanking them all for what I think has been an excellent.
Well, thank you to our panelists and to our moderator for sharing their views on third-party funding and for making this session so engaging. I will now invite Professor Emilia Onyema to present a token of appreciation to our moderator and panelists on behalf of the organizers. Thank you. So, ladies and gentlemen, we now reach our third and final session of the day, focusing on the impact of investment claims on states and investors. This third session will be moderated by Professor Martin Lowe, who is a professor of South Asian law at SOAS University of London. He is a member of SOAS Arbitration and Dispute Resolution Centre, a barrister at Essex Court Chambers. He is also a Chartered Institute accredited mediator, and he sits as arbitrator. He has held visiting academic appointments at Harvard Law School and Nagoya University, and he is the editor-in-chief of the YEMEL, the Yearbook of Islamic and Middle Eastern Law. Join me in welcoming on stage Professor Martin Lowe, along with Ms. Angeline Welch, Professor Stephen Finizio, and Mr. Beju Vazani. Thank you very much.
Yes, thank you very much, dear Amel. And I can disclose that there was one little piece missing when Dr. Amel Makhlouf was introduced, because Amel and I work very closely on the Yearbook of Islamic and Middle Eastern Law, because Amel worked there as an editing manager for articles for 2 extremely successful years. So it's really wonderful to see you here as our Master of Ceremony and as a member of the SOAS Arbitration Dispute Resolution Center's Management Committee. So wonderful. Thanks so much, Amel. And I have this wonderfully pleasant task in some ways, you know, like my connection to Amel, I'm in one way or another wonderfully connected to all our speakers. Our panel looks at international arbitration and state sovereignty, in particular the impact of investment claims on states and investors. I myself actually don't have any direct practical experience, but in some ways I have a personal experience on this. I work quite a lot in Pakistan and on Pakistani law, and Pakistan, as some of you may know, is one of these curious examples where a human rights suo motu action by the Supreme Court of Pakistan actually triggered a multi-billion investment claim in the Rikudi case. It's also an example of a successful mediation and dispute settlement, because this matter actually has been resolved without any kind of damages having to be paid. But of course, our speakers will address this topic from different perspectives. Now I said I'm kind of connected to all of our speakers in one way or another. So I'm going to go kind of down the line and start with Professor Stephen Finizio, who is a professor of practice at SOAS, where he teaches arbitration law and international investment law, but he's also a partner at Wilmer, Cutler, Pickering and Hale and Dorr here in London. He sits as an arbitrator and has acted as counsel in commercial and treaty arbitration and matters involving the laws of jurisdictions. It has to say, apart from kind of outer space, everything is mentioned. So in a truly global practice, he's also a member of the ACIA Court and the GIAC Advisory Council. And I want to mention this because his team won a landmark decision in the first freedom of expression case in the African Court in Human Rights and People's Rights. I won't list his publications, please just look that up on the internet. So I'm moving to Angeline Welch, and I also have a connection to her because, you know, she is a barrister at Essex Court Chambers, and I've myself been fortunate enough to be there as a tenant for 25 years. So Angeline is a KC and has a very extensive and broad range commercial litigation, commercial disputes practice. And she's also been leading on judicial review and constitutional cases in the Caribbean. And she has a very busy investment treaty practice. So we are very fortunate, Angeline, that you've joined us to speak today. Last, not least, and again, a connection I do have with Baiju, apart from our mutual love of chai masala chai, is that Mr. Baiju Vasani is a senior fellow a senior research fellow at SOAS University of London, and he is a barrister and an arbitrator at 20 Essex, London. And Baiju, I think this is also remarkable, he holds 4 degrees in law, an LLB, an LLM, a BCA and a JD from respectively King's College London, LSE, University of Oxford and Northwestern University of Law. And yeah, we're very happy to have you here, Baiju. Thank you very much. And without further ado, I'm going to explain to you roughly how our panel works. I'm going to ask questions to our panelists. They will answer them. Then we will have a few reflections in the conversation within our panel on that particular issue. And then we will move on to the next panelist who will then address the next question. And I will make sure, or try to make sure as a moderator, that we will have ample time for discussion and questions and answers. So my first question actually goes to Angeline. And really my question is for her to explore the impact of investment claims on the relationship between the investor and the state, and its impact on economic development of states and commercial viability of foreign investors. Angeline, thank you very much.
Thank you very much, Martin. So I've been charged with, oh, it's very loud. I've switched off. Okay, hopefully now that works. So I've been charged with answering, I think, what is quite an impossible question to answer because many others have tried to work out what the impact is of investment treaty claims on the economic development of states, and the answer is pretty inconclusive. So I'll explain a little bit about the background of why this has been intensely looked at. And I think ultimately what is interesting about this particular topic is that one can look at the economic contribution which investment treaties and the outcome of ISDS cases made to the economy of particular states, but actually the question is much broader than that. And ultimately, where we are at is that there's not a complete abandonment of the system, but what we are looking at now is reform of the system. And one can look at the reasons which have led us to that point, and I'm sure we will do with my other speakers during the course of this session. So a little bit about the history. Unquestionably, there has been a significant rise in investment treaty claims, and I'm sure most of you will be very well aware of that. That has coincided with obviously an increase in investment treaties actually being signed. So prior to 2000, there were only about 44 investment treaty cases which started, but after 2000, we're into well over 1,000 cases which have been commenced. And so one sees that, unsurprisingly, there has been an increase in investment treaty claims at the same time as there's been a rapid increase in investment treaties and in cross-border capital flows. Some analysis of the cases to date have said that by 2018, 2/3 of the respondent states to these investment treaty claims were developing in terms of the aims. The other contributing factor perhaps in terms of economic development that one might point to is what is being described as regulatory chill. And why do I say that's a potential economic impact on the development of states? Well, of course, states need to take regulatory decisions in order to change their economy. And one of the issues which has been flagged with investment treaty claims over recent years is this perception that where there's a change in government policy, this will result in more claims being brought, which then inhibits the state from making policy changes in order to strengthen its own economy. Now, that's obviously something which is quite difficult to empirically measure, but that is certainly a repeated concern which has been flagged, particularly over recent years. So that paints, I think, quite a sort of potentially negative picture of investment treaty claims from the economic perspective. But I think the question really is, what does this have? What do those sort of indicators have on the tell us about the development of investment treaty claims or going forwards, or in the investment treaty infrastructure? It's fair to say that there are some states who've sort of taken what you may describe as a more nuclear option. So they've terminated or withdrawn their investment treaties, or they've moved away from ISDS. But actually, really what we've seen, I think, is an emphasis on reform rather than complete abandonment of investment treaties completely. So I was going to give just 3 examples, if I have time, as to how states have looked at using investment treaties to strike a balance between economic development and providing reassurance to foreign investors that investments in their host states will be dealt with in a fair and secure way. The first is the example that we have from Brazil, of Brazil's Cooperation and Facilitation Investment Agreement, which is interesting, I think, because although Brazil itself has signed 14 traditional PITs between 1994 and 1995, they never received National Congress approval. But that hasn't really led them, Brazil itself, to say, okay, well, we're just going to completely abandon the idea of doing any investment treaties whatsoever. They have developed, as I said, the Cooperation Facilitation Investment Agreement in order to facilitate foreign direct investment. And what that does is it provides essentially a cooperation mechanism between the state parties to the agreement. So each party must create a centralized mechanism an ombudsman, if you like, who will receive investor queries and demands. And then the ombudsman analysing demands and questions posed and coordinates with government entities in order to expedite proceedings and deal with those complaints. And then there's also a provision for a joint committee for state-to-state cooperation and dispute prevention. There is no ISDS in those treaties, but they have been signed with Angola. A number of states, I won't name all of them, and at least 2 have received congressional approval. So that is a movement away from investment treaty claims as such, but it does signal that there is, I think, a desire to continue to have these agreements and cooperation, and recognising that they do play some role in foreign direct investment. The second example I was going to give is that there are numerous examples now of where more recent treaties have adopted language which is designed specifically to create regulatory space. And many of you might be aware of this. So a review of the investment agreements signed between 2018 and 2020, 36 in total, showed that some of the most common features dealing with creation of regulatory space and investment treaty were to include language in the preamble of the treaty itself to preserve the right of the host state to regulate, exemptions for regulation, usually in the context of indirect expropriation, and exemptions and non-precluded measures, so recognising situations where it would be permitted for states to impose measures that may impair investor rights. So rather than complete abandonment, what you're seeing is the new treaties which are being entered into are just trying to make clear that the balance between the regulatory space in order to achieve economic development and investors' rights is more balanced. And then a final sort of development to mention is that we may, I think, see in future years more sustainable investment provisions in investment agreements, which is part of that sort of counterbalancing the rights of host states and investors, if you like. But that may require certain obligations on investors to ensure that there is sustainable investment in states, for example, through the adoption of requirements for investors to include due diligence and reporting requirements. If you think about some of the sort of business and human rights requirements that we're seeing more recently, or developments relating to climate change, then you might see those more readily adopted investment agreements. So what that shows, I think, is not a complete abandonment, but actually in a transition in order to ensure that investment agreements are fit for purpose when it comes to ensuring it encourages foreign direct investment, but not at the expense of the individual development of the state. And of course, there's a number of procedural reforms that the Under-Trial Working Group number 3 is looking at the minute, also might be said to be connected to that, but I will leave my fellow panelists to pick up on that particular topic.
Thank you. Thank you very much, Anjali, for this very informative kind of first contribution. Beju, do you have any reflections on kind of the question or the topic Angeline kind of raised before we actually move on to your topic?
All I would say is this, that young practitioners come to me and say, should I do ISDS? And the answer should be no, because it's a dying breed. But the answer is probably the opposite, that ISDS continues to be a viable form of dispute resolution. I would say the best form of dispute resolution for foreign investment. The BITs that have been terminated are largely within Europe and certain countries, but there are thousands of BITs that continue to be enforced, plus hundreds of BITs that continue to be put into place. Now, I think Anjali makes a good point. Well, there's little connection potentially between FDI and BITs, but I think there are other reasons that states sign treaties. Symbolic reasons, friendship reasons, trade reasons. And so I think we're going to continue to have this form of dispute resolution. The only question is, in the modern treaties, are we going to see the same type of dispute resolution, or are we going to see
nuances as to how it's going to take place. But I think the format as such of treaty protection will stay in place for the next 20, 30 years.
Interesting. Stephen.
Well, I think picking up on what Angelina and Beju both said, it's incredibly difficult to measure. And one of the questions is, what are we trying to measure? What is the goal? And if you put it in terms of increasing foreign direct investment, the studies don't seem to show that you can draw a clear line between investment treaties and foreign direct investment. On the other hand, they don't show that you can't. And the problem is we're also dealing with a changing world. And I think this is we start to then talk about anecdotes, and I think that's dangerous, but a couple of anecdotes to sort of spark the conversation. One is when the Commonwealth studied arbitration a couple of years ago, they had an economist look at the effect of implementation of the New York Convention on foreign investment. And there was a clear correlation between ratification implementation of the New York Convention and foreign direct investment. Now, measuring investment treaties is much more difficult, because particularly BITs, because it's not the same thing as ratifying the New York Convention, but it makes you wonder, investors were paying attention to the state of the law by reacting to a country implementing the New York Convention. So it tells you that there is an audience paying attention. And I think when we think about audiences paying attention, we're in a world right now where we mostly criticize ISDS, and we're talking about reforms, and what it has done, perversely in a way, is to raise attention. And there are a lot of investors who still have never heard of investment treaties, but more and more do. More and more lawyers have heard of it, which part of the reason why we see more and more claims is more and more people are aware of treaties, which does, I think, mean that in the last, and I would say the last few years, and I don't know how to count years anymore with the pandemic, but the last few years, you are starting to see investors consider where to put their investments based on one of the factors. It would be investment protections. And maybe it's a decision between investing in India and China, for example, but investors are increasingly educated in this. So I do think if we tried to measure today whether there's an impact on foreign direct investment, it may look different than it looked 5 years ago, 10 years ago.
Sorry, Martin, I would just say to Angeline's point on countries that don't have treaties, but yeah, have good FDI. I don't think necessarily, certainly the investors I've worked with, it's a question of whether they're going to invest in a country or not, but just how much their IRR reduces or increases depending on how much, and that affects the way they view the investment. I don't necessarily think it changes whether they're going to invest or not.
Yeah, interesting. And Beju, your comment about kind of reasons states enter into BITs is also an interesting one. So I just share this anecdote that when Pakistan was faced with the first kind of exit claim, and I think it involved a BIT with Switzerland, they just couldn't find the treaty. And they actually had to ask Switzerland for a copy because it had somehow gotten lost in the foreign ministry. And, you know, of course, now Pakistan is a very sophisticated kind of participant in these types of claims, but it shows kind of the history. I think Pakistan was one of the very first countries to actually enter into a BIT. And clearly by then, at that point, you know, there was no history of exit claims or the Sultan of Sulu kind of case. But Beju, you wouldn't have to ask me even for permission to make this contribution, because it is your turn in any event. And Beju is going to explore with the panel and the audience the wider impact of investment claims on the relationship between the home state and host states. Beju, please.
Thank you, Martin. So the question is the relationship between the home state, that's the state that shares the nationality with the investor, and the host state that has the investment and with whom the investor has the dispute. And the question is, well, how does the claim affect their relationship? Now, if ISDS is working properly, the answer is that there should be no impact on the relationship, or at least reduce or very little impact on the relationship. And that is because the very purpose of ISDS is to depoliticize disputes. So if we take ourselves back even 60 odd years about,
maybe a little more than that. Investors did not have, of course, the direct right to go against host states. They were merely seen as an emanation of their home state, a part of their home state, and it was for the home state to espouse their investors' claim before the host state. Now, of course, whether a home state chose to do that was somewhat potluck, depended on how powerful you were as an investor with your home state, what kind of claim you had, what was the other situational relationship between home state and host state at the time. But what was sometimes increasingly clear was that the home state was more powerful than the host state. And you did have instances, and I won't name names, but Professor Amelia has a lot of anecdotes in this in our class, where more powerful home states at the time used what is called gunboat diplomacy to force host states to comply, allegedly to comply with international law. The ISDS system then was designed to remove any entanglement between the home state and the host state, because now the investor had the direct right to go to a legal forum to seek redress for their grievance without home state involvement. In fact, not only was home state involvement reduced, it was prohibited in the ICSID Convention. So if you look at Article 27 of the ICSID Convention, it says that no state shall give diplomatic protection to their investor once the dispute has been submitted to ICSID. In other words, home state, you stay out. This is now a direct relationship between the investor and the host state at ICSID. Please don't have any interference in the system. Now, I'm going to let you into a little secret, which is not so much of a secret, but espousal, of course, still goes on. But it depends on the relationship and the relative power of the various nations, just as it does when nations negotiate bilateral investment treaties. Bilateral investment treaties are by their nature synalagmatic. They are mutual. They are what's good for you is good for me. It doesn't matter if it's you or me. It's absolutely at idem. But the fact is, of course, that whose model treaty is used depends on who is the more powerful nation, and the more powerful nation can put in things that are better for their investors than it is for the investors of the other side. So it is rarely in negotiations a level playing field. The same is true when there is this behind the scenes espousal. A powerful government can raise the issue of their investor at, and I'm talking about president to president meetings, president, prime minister meetings, behind closed doors meetings. These things do come up. Now, sometimes I would say that's welcome. I think it's good that there are settlement of these issues without resort to ISDS. But other times, I think it's wrong, because the ISDS system, as I've said, is designed specifically to avoid this kind of political entanglement. And I would say the US government comes under a lot of criticism, but the State Department is actually very good at keeping itself out where a situation has already found itself to arbitration. So then let's move on to what happens during the arbitration itself. What does the home state do? Oftentimes and increasingly, we see home states come in with an amicus submission. And they like to make amicus submissions on interpretation of the treaty. And now you would think that they're there, their investor is there with a claim against the host state, and you think that the home state would side with the investor. Usually not. Usually their view accords with the host state. Why? Because they take a very, today, not in the 1980s, but today, a very narrow view of the meaning of umbrella clause or the meaning of MFN or jurisdiction. And that is because they take the same position when they are the defendant in other cases, and they want customary international law to go along the lines of a narrow interpretation today of treaties. Now, by and large, what a state says today about something it wrote in the early 90s should not matter, because international law says that what matters is what was said and meant at the time. But increasingly, states are putting into treaties that what they say now actually is persuasive, or must be persuasive to what the tribunal determines. Sometimes they even say it must be obligatory of what the states determine. What other relationships is there between the home state and the host state? I've been involved in many cases where there is under the surface criminal investigations of the investor. Now, sometimes that's right, sometimes it's not. But you have diplomatic correspondence, you have a sort of pseudo discovery process where outside of the international arbitration process, a state-to-state relationship takes place where they talk to each other and they exchange information on the investor. And that is something, of course, that the investor doesn't have. It creates somewhat of an imbalance. Then when the award is rendered, diplomatic protection, at least under the ICSID Convention, ends. And the home state can very much be involved in trying to force enforcement of an award. There are lots of instances of home states involved at the World Bank, the IMF, trying to reduce credit ratings, claiming bond and loan defaults, refusing to sign Trade Preferences Act, just because it claims that a host state refusing to pay an award is a breach of international law. Now, I just wanted to make, Martin, a couple of additional points, which I think are very interesting in the notion of home state, host state, and BITs. One is what I call and others call lawfare. So that is where two states which have a treaty are at war. And Ukraine and Russia is a very good example. So there is, as you know, a BIT between Russia and Ukraine. And what Ukraine has done is what its Ministry of Justice has said, that it is using lawfare, which is the BIT, to assist its investors to sue Russia for expropriation of investments made into Crimea. And it sees this as a form of war using the legal process. So it's very interesting when you have disputed territory, when you have disputes between two states, and the BIT, which in good times was meant to have mutual prosperity, is now seen as a tool for either aggression or defense, depending on how one views any political situation. Similarly, you have very interesting situations where two nations don't recognize each other and they don't have a BIT, but they're both signatories to a multilateral investment treaty, but they forgot to make a reservation between them. And now someone from a shareholder from one nation who has a company in another nation sues that third nation, and they're like, oh my God, I'm being sued, but ultimately by the UBO, who's from a nation I don't recognize. Again, it adds this political element between the home state and the host state. Other times, home state and host state come together to denude the investor of their rights. Let's think of the EU. So at a swoop, a number of EU nations got together, signed these treaties that simply wiped away intra-EU treaties. Not only that, but they sought to wipe away the sunset provision in those treaties. So it's like a double termination, and therefore leave a bunch of EU investors ostensibly, and I say ostensibly because I have particular views that international law cannot allow a denuding of investor rights once the investment has been made in reliance of the treaty, but to denude ostensibly these investors of their rights. So again, home state and host state can very much come together. And again, that is a political situation because it's about supremacy of EU law. Finally, where states can come together, and I don't want to take a view on the Sulu case, so I'm going to say that initially, but where there are cases where the system, the ISDS system, has been abused. Certainly, we know of other cases where the system has been abused. And of course, the system is almost ripe for abuse because there are billions of dollars potentially at stake. You have
third-party funding available to bring cases. You have very clever and creative lawyers who will come up with ways of winning cases. And there are, unfortunately, a history of such cases. Now, Malaysia says this is one such case. I've read the case myself. I think there are certainly questions for the claimants to answer. But regardless of that, you're going to have a situation where Malaysia must, if it truly believes that this is a case of an abuse of a system, it must engage with other states, Philippines, Spain, France, to insist that the system not be abused in this way, and to come together as nations to say that we collectively have to stop this kind of abuse. Now, of course, as I said, I don't take a view on the particular case, but in these types of cases, and there have been other cases that are proven to be fraudulent, I think it's very important that home states and host states work together to root out this type of abuse.
Yeah, thank you very much, Beju. That was, very, very interesting indeed. Angeline, reflections on the same topic in light of Beju's submissions.
Thank you, Martin. I mean, there's such a lot that Beju has covered. I suppose what I was going to comment on in particular is the use of the home state in any deliberations or where a dispute arises between an investor of that home state and the host state. So as Beju said, and I also have experience of this, that sometimes investors go to the home state in order to bring pressure to bear on the host state. And I was thinking about that, particularly in the context of the Brazilian agreement that I mentioned earlier, because if an investor is essentially relying on or is placing some weight on the home state in order to make a difference in their dispute with the host state, then it seems to me that that is probably not ideal, to say the least. And the reason is that one can well imagine that actually, if the home state the extent to which they put pressure on the host state will very much depend not only on the strength of their bargaining position, as Beju was just saying, but also on the priority of that particular investor or that particular dispute to the home state. And so, while I think it is a very interesting angle, and it is interesting to see that there is more and more emphasis on cooperation between states as an alternative to some of the investment settlement, the settlement dispute resolution provisions. Ultimately, I think it's really wouldn't be much comfort or cold comfort for investors in these circumstances.
Just really quickly, I'm going to pick up on a theme that will play into what I'm going to talk about next, which is the costs involved in this. And the constituency who I think often gets overlooked in this whole process, which are SMEs, who often can't afford what the system has become, as much as we care about states and the impact on states financially, and I'm going to talk about that in a minute. There are, I think, a lot of smaller investors or investors with smaller claims, or particularly small investors with small claims, are frozen out of this process. And this is where you see a great reluctance, and Angeline just said, you know, the priority of that investor to the home state, right? And this is where you do see a lack of engagement. And I've had experiences with the FCO here in a case involving a British investor in an African country, where first we had to explain that there was a treaty, and we had to explain what the treaty was. And then they said, well, we can't help you. The treaty says we're not allowed to help you once claims are launched. Well, we said, but there's no claims launched. And we're at a point where there's a serious dispute, and would be really helpful to get some engagement from the home state investors' government. And they absolutely did everything they could not to help. And that's an opportunity with a disadvantaged investor who really needed that help. And you see it again, and Beju talked about, the US will parachute in lots of treaty claims and tell you as the US investor why the standard at least is much narrower than you want it to be, which is not brilliant. But also under the new USMCA, the treaty that's replaced NAFTA, under some of those treaties, one of the states has to say that there was an expropriation. And the US has several times, without any engagement with the investors, said, no, we don't think there's an expropriation, which obviously kills the claim. So there are times where you wonder whether the system has gotten so formalized and the incentives are so strange now that rather than solving problems, we are actually exacerbating problems in the sense of making treaties work to do what they were supposed to do if they're treated in a healthy way.
Now, this is kind of the perfect transition. Steve, just a second. Yes, so our panel, all three kind of topics ask panelists to explore. And in some ways, the first two contributions kind of explore difficulties and challenges. But we thought that this was kind of perhaps a kind of dissatisfactory kind of end to our day. So in fact, we thought we're going to look at something positive as our very last kind of topic. So Stephen is going to explore with us how investment claims can be better managed, particularly the idea of an investment advisory center for states, which potentially actually could address many of the issues we've been discussing and debating over the day. Over to you, Stephen. Thank you.
Well, now the challenge is to be positive about this. I'm not sure I was going to be positive about this.
I saw your notes.
We talk about reform, and we're in a phase of very focused reform discussions. And I don't know how familiar everyone in the room is with these ideas, but we've had several references to Working Group 3. There was references in earlier panels to Working Group 3, which is at its trial. It is an effort to think about reforming the ISDS system. It's been going now for, I think, 6 years. We're going into our 6th or 7th year, but we're at the stage where we're supposed to have identified several key reforms and starting to move to the concrete implementation of proposals, at least, so that there's something to vote on. And most of the time we talk about the multilateral investment court approach, which thankfully we're not going to talk about today. We're going to talk about one that flies under the radar a little bit, which is the idea of creating an advisory center to help particularly and this is the phrases that I use, low income and developing states in particular, in terms of both knowledge sharing, best practice sharing, but also, and I'll explain this in a second, assist in representing those states in proceedings. This comes out of a series of efforts to do this previously, and there's been several failed efforts, and this is why I can't be so positive about this. There have been several failed efforts in South America to put together regional advisory centers. There was one in Asia as well that has not really managed to go forward. And so whether this one, which is coming through a sort of a more global and more sort of a process getting more attention, will succeed, is where I can't tell you for sure, and I'll tell you why in a minute or two. One of the things that has killed previous proposals, but it's the Working Group 3 model is based on what the WTO does, and it does work with the WTO, and therefore maybe through this process there's a chance that this will work better. So the idea is to try to help states have a level playing field, and to create a center that will help in that regard. And under the most recent version of the proposals that will be discussed in the next couple of sessions of the working group, there are two types of activities that the advisory center would assist with. The first is what's called technical assistance and capacity building activities, and specifically the current proposal in draft provision 6 talks about an advisory center that would advise those states who are members of this center on issues pertaining to dispute prevention and conflict management, provide training with regard to possible means of resolving disputes, including but not limited to arbitration, but also mediation conflicts, function as a forum for the exchange of information and sharing of best practices. So that's this kind of capacity building technical side. And then I think the more interesting and the more controversial side is proposal 7, which is to assist with regard to ISDS proceedings. And under this proposal, the center would be available to provide a preliminary assessment of a case, including advising the state on appropriate means to resolve a potential dispute, assist the state in selecting mediators, arbitrators, or experts, support the preparation of statements, pleadings, and evidence and other aspects of proceedings represent the state in an arbitration, including at hearings, including jointly with a team of that member state. Now, the way it's phrased, and partly this is preliminary, suggests that there could be circumstances in which the center would be the sole representative of the state. There's also the idea of engaging with external legal counsel again. So it's suggesting that the state there may be external legal counsel, maybe there isn't, if this full capacity is established. So this is the idea behind it, which is then, of course, it raises a couple of questions. One is what it hasn't done is it hasn't included my small and medium-sized enterprises. So this is purely at this point a one-sided center that would assist states. There are open questions about where would it sit, and both conceptually, would it sit within a particular international organization, or would it sit separately, and where would it sit physically? One of the proposals is to have regional offices with local staff who would be more aware of local customs and cultures and customs. But here's the big question, and this is why I can't be so positive about it. Of course, all this stuff turns, among other things, on who's going to pay for it. And the current, in the most recent draft, the proposal is that those who join the center will pay an annual fee. Plus, if you use the center for the representative services that I described, you'd pay additional fees for the services that you use. But this is the thing that has killed a number of the other attempted advisory center proposals in the past, is figuring out who's going to pay for it. And it takes us to this question of cost, which is a much bigger question. And we, from the previous panel, talked about this a bit. And we have various ideas beyond this about how you could do this. Now, the WTO approach is to have all WTO member states put some money towards this, plus the people who use the advisory center. I don't think that's so far the leading proposal for our working group 3. We talk about other broader reforms, including the idea of taxing awards that was floated at ICA last year. But this is the sort of the elephant in the room, is how do we pay for what's become a very expensive and cumbersome process. And obviously, if the center really were to exist to be to play that representative role, there'll be scarce resources that will have to be divided between different member states, and all that starts to worry you about the practical side of this. But funding, independence, those are big issues. How to make sure that it enhances and complements existing organizations that also help with capacity building rather than competing with those. How actually not to have an advisory center in some ways encourage more claims. I mean, that would be a sort of a backwards result, potentially from a state's perspective. Generally, if you're going to have a center like that involved, does that slow cases down? Does it add costs? And then what people haven't really engaged with so far, but actually I think a difficult question, is if you've got a centralized set of lawyers who are advising multiple states, one of the ideas is that they're creating a consistency. They're taking positions that will be shared across different disputes, but you're creating an advocate taking substantive positions about international law and the impact of that, who's going to do it, how they're going to decide to do it, and if they have access to confidential information about different disputes by different states, how you regulate and prevent those sorts of confidentiality or deal with those sorts of confidentiality. So there's a lot of practical issues if the role moves beyond training, technical and capacity building into this representation role. But it is part of, I think, what we're seeing right now, which is a pretty robust approach to think about how do we deal with the things that are causing us the biggest problems and cost, and across the board for both investors and states. The cost of the current process is a huge problem. And so this is one way, we may start to level the playing field, at least to some degree, if we can think about ways to do this in an effective way. So it's watch this space with all the working group 3 things. I mean, we don't know what's going to happen, but this is one that at least has gotten less criticism than the court. And so, as I said, it flies under the radar a bit. So on one hand, it's less controversial. On the other hand, it's not getting attention, which may mean it doesn't have as much chance to succeed. We'll see.
Yeah, thank you much, Stephen. I must agree, it was perhaps, I think there were many positive aspects in your talk. And the only kind of weak point in the system seems to be the money. And I'm sure that can be best, it's only money. And I'm glad that there's this kind of reflection of working group 3 and our panel 3. Beju, do you have any reflections on how to improve the system?
Yeah. Well, actually, I don't want to end, maybe Angeline will end on a more positive note, but I want to be a little critical of states because this whole thing is their system. ISDS is their system. Investors didn't create the system, states created the system. States have control of the system. And then it always strikes me as somewhat hypocritical where a state complains about the cost and then they hire the most expensive law firm. Why? Why don't you hire other very competent counsel? And then they say, you know, these arbitrators, they don't take into account developing countries' needs. And guess who they appoint as arbitrator, right? Instead of the people who would actually wear the same hat, and there are some sitting in this room. So I have to say that as much as I love the idea of a center and all this kind of stuff, I think now, today, it is within the hands of the states who are being sued to take control of their own destiny in this situation, build capacity. If you go to and I'm sure there are some LLM students here, but you have people from all over, certainly we teach LLM students from all over the world. If they go back, having done our class, of course, and have the capacity and knowledge, why are they not taking that in-house and saying, we'll work with a few lawyers in a cost-efficient way with our in-house capacity, which Argentina have done, the Czech Republic have done, and others have done very well. The United States, of course, has the Canada. But it's very open to nations to do that. And then once you get those lawyers will hopefully appoint the arbitrators who are taking more of an approach that is akin to the understanding of international law and, of course, local laws and customs that these developing states have. So I think the answer is already in their hands if they were to grab it.
Yeah, I just want to come back on a couple of ways and argue with you slightly on some of this. But one of the things that's interesting is the cost situation, regardless of whether you're hiring the most expensive or local. The world has changed pretty dramatically in terms of cost allocation in treaty arbitration in the last 10 years, and particularly the last 5 years, where we're seeing now cost allocation done in treaty arbitration the way it's traditionally been done in commercial arbitration, and states have benefited from that. So it's another thing that complicates the picture. You say no, but the statistics I think are pretty strongly.
Okay, no, I agree with you, Steve. But those investors are SPVs. They're not going. They don't actually pay the costs, right? So it's an SPV in Luxembourg or in, I don't know, BVI. You think those costs are actually paid? Absolutely not.
And that's a question. Then we're going to get into the weeds. But that's a question of whether we need to be using security for costs more often as well, and the funders from the
or the third-party funders, yeah.
Have a view about that. But I do think the world has changed a bit, and states, if they want to use whoever they want to use, I agree with you about growing local capacity. But I think part of the way to do that is to work with experienced lawyers as you develop that capacity. And I think the crying poor when you have now a cost-shifting regime is more complicated than it used to be. And the other thing I'm going to say, which is going to make me really, really unpopular, is that, and Emilio will probably throw something at me, but statistically, when we study treaty arbitration, one of the things that does correlate to outcomes is picking experienced arbitrators who come from that group, and what states have done to improve their success. And we want to change this in terms of we want to expand this pool, but the more that they pick the certain names they pick, the more they win. And so the question is, so states, to be smart, need to pick the right arbitrators, and we need to expand the pool of the right arbitrators. But it's right now the smart move for states so it's a question of then getting the right arbitrators who can do that. But at the moment, statistically, at least the last time somebody did a real heavy study of this, the thing that correlated with success was for states was picking people from the pool that you don't want them to pick from, which is I'm just speaking facts. I'm not advocating.
Yeah, thank you very much. So I'm still, hoping for this bright ray of sunlight coming from Angeline.
No pressure, no pressure. Well, let me Let me make the case for having an advisory centre on international law. I mean, obviously there's problems, and I would add, so I'll say something a bit negative. I would add to the sort of the costs problems that I would have thought if you're a state, you probably want your own legal representation rather than to take from some advisory board. So the question will be, well, how much would the cost of the advisory service representation specific service be versus hiring your own law firm? And actually states are, in my experience, reasonably savvy these days in terms of procurement for law firms. And so I'm not sure that they necessarily always choose the best and most expensive law firms. But just in terms of the advisory centre, let me try to end with something a bit positive. Beju gives some examples, I think, of states which have developed their in-house capacity. But many of those states, I would suggest, are states where there has been a sort of need for that capacity because they've been on the receiving end of a number of investment treaty claims themselves. There will be many states out there who don't necessarily have the same sort of impetus to develop their own capacity building. And so an advisory centre would at least concentrate that learning and give access to develop some capacity for a much broader range of states. And of course, it would concentrate it within one body rather than it being diverse. There is, I suppose, one can say that I think Steve is right, there are issues obviously around information sharing and confidentiality if you have a body which is representing another different states. But then we have law firms who specialise in representing different states, and they are perfectly well able to manage. The question, it seems to me, is that if you institutionalise legal representation in this way, does it become more difficult for those representatives to take different positions on matters according to the best interests of their clients, or will they be seen as an institution which represents a particular issue or perspective? And so, having said I would try to make something positive, I think I've said both positive and negative in my final remarks. Apologies for that.
Yeah, dear esteemed panelists, thank you very much for a wonderful discussion. There were times when I thought I'm actually inside an SOAS LLM seminar and not at an international colloquium, so wonderful. But we still have a little bit of time for a Q&A session. I think we also have a microphone, so over to you, the audience, to participate in this conversation and discussion, either with comments or questions, please. If you could just briefly introduce yourself as well before you ask your question or make your comment, please.
Thank you, the moderator. First of all, I'm just listening to this colloquium as a historian, and my understanding is very basic on the matter. Before I ask the question, I have to make a certain remark, a couple little remark on this. In this morning session, after listening to the argument proposed by the morning session, I have the reservation that the current case, the Sulu case or the Sulu fraud, could end up to be like the Pulau Batu Putih decision. It can go either way. But I'm interested in the which panelists I cannot recognize saying that the matter could be solved if the home state and the host state work together, collaborate to establish collaboration to avoid this kind of so-called third funding international arbitration case. By not losing the case, the idea is not to losing the lawyers to solve the problem. But if I understand that, we need lawyers because the case had been brought into court. So there is no way to avoid using lawyers. Secondly, This, as far as I understand from this colloquium as well, and from my reading, the case had been brought to the court just because of the New York Convention, which allows the investors to invest on this kind of international arbitration for third funding. So it is allowed. So in this case, I perceive that, I reckon that the Sulu as the purported Sulu as had been assisted by investors to bring the case to Spain and also to France. But I am quite shocked to find that how come Spain and France can interfere into the internal affairs of what other nation? This is what I don't understand. Thank you very much.
Yeah, thank you very much, Professor Abdullah, for your comment and reflection. Please.
Yeah, but my point was very simple, and we were talking about how the impact of an investment claim could be on the home state and the host state. And my point was that in cases where the system has been abused and an award has been rendered that is truly fraudulent, then I think it is right that governments get together to root out that type of abuse from the situation. Now, in this particular case, as I said, I don't take a view, although as I said, I do think the claimant has questions to answer. But the reason that France and Spain have, and the Netherlands have the right to have a say is because that is where the award emanates, that is where the award is enforced. I think it's very important that international due process take place. But at the same time, if it's found by all of those nations that there is some defect in the award such that it should not stand, then I think it's very important that governments get together to denounce that type of abuse. But I think it's very important that due process be allowed to take place and that not be seen as interference in the process.
I guess I just want to make a broader statement. If we're talking about the ISDS system or the international arbitration system being a system which allows arbitrators to interfere with the internal affairs of a state, the answer, I think, has to be it's only when states have agreed that they are either going to allow something to be arbitrated that deals with their activities, or they're offering protections to investors. And in this case, I think Beju just said this, the courts in France are not actually regulating Malaysia's activities. They're actually acting to protect Malaysia's interests in the sense of saying, is there jurisdiction here? And therefore, I think it's got to be careful about how we talk about this, because we need, I think, to be really precise about what the system does and doesn't do. And obviously, we can all talk about the outcome in various cases, particularly in the treaty space, having something to do with a tribunal, and then the courts in the process saying something about governmental activity. But that's because governments have agreed through treaties to have their conduct regulated. So I just think we have to be careful about oversimplifying some of these in terms of the drama that we add to the way we talk about it.
Anjin, you want to say anything?
Nothing to add. I mean, just as Steve said, the French court is regulating the arbitration process rather than.
Right.
So,
Yeah. Excellent. Yeah, thank you very much, Professor Abdullah. Another question, please. I go a little bit further to the back because Mr. Issa in the previous session. But I have not forgotten about you, Mr. Issa.
Hi, thank you very much. My name is Jessica. I'm a student at Queen Mary doing my LLM there. I have a question for Miss Angeline at some point, but also open to the rest of the panel. So at some point during the discussion, there was a mention about how in the future, investment treaties would move towards the inclusion of climate-friendly provisions. So my question is then, how do you reconcile the tension between states who are moving towards the enactment of climate change friendly provisions versus investors who are affected by these policies? So we have seen cases like RWE and even UNIPA who have brought cases against the host state for, the phasing out of fossil fuel. So how do we reconcile this tension, especially within the ISDS system? Thank you.
So the question, I suppose, goes to the current system as opposed to what it may look like in future. I mean, I think part of the issue here is one of the things that I talked about was the right to regulate and this idea of regulatory chill. So if you're moving from one policy to another, government policy on extraction of natural resources or whatever it might be, then there is already, I think, currently within the current framework, the recognition through case law that there is a right to regulate. What the states are doing with new investment treaties is just making that in a way clearer that there is a specific right to regulate. And of course, that probably in some ways creates more regulatory space because you have the language there rather than relying on a treaty tribunal and the case law which already exists. So there is, I think, within the current system already the ability to take account of the fact that states will have international obligations, particularly under Paris, but perhaps increasingly under other agreements as well, in order to address climate change. And they're going to have to make policy decisions which will affect investors as a result of that. That's something, that balance to be struck between whether or not the host state is liable for that regulatory change is something which I think can be dealt with in the current system.
Thank you very much, Angeline. We have a bit more time, and I know that Mr. Issam would like to ask a question, but given that he already asked a question in the last panel, if there's anyone else now to ask a question, Mr. Issam, please, it's your turn. We have an online audience, so it would be useful for the microphone to work.
Hello, is it working?
Nope.
Hello.
Now it is. Some member of the Beirut Bar Association. I just wanted to address the impact of bilateral investment treaties on economic development and show that it is actually a chain and bilateral investment treaties do impact economic development. It's a chain that some countries do not yet have national or domestic foreign investment laws. So therefore, the investor would want to rely on substantive grounds where they look at two key factors: efficiency from one side and certainty from the other side. And if the country does not have a framework for foreign investment law at the domestic level, then a bilateral investment treaty would be very helpful to give the foreign investor a sense of promotion and protection. And the bilateral investment treaty, in its definition, it's an agreement between states for the promotion and protection of foreign direct investments. So if it promotes foreign direct investment, then it's promoting economic development on one level. And Mr. Bajus mentioned narrow interpretation. On the other hand, narrow interpretation could also be addressed in defining investment, where a host state does not have a national foreign investment law. You would need a bilateral investment treaty to define investment so that an investor who is investing at the host state would actually know if they fall within the category of investment that this host state regards, yes or not. So bilateral investment treaties do actually lead to the promotion of foreign investment, which therefore promotes economic development.
I will jump in before Angeline, although it went to her topic. I think we have to take it to its basic, which is that investors invest to make money. And if they believe they're going to make money, they're going to invest, right? I think that's just step one. That's just human nature. It always has been. It's a capitalist system. We get progress because people want to make money. They want to make a return. And BIT or no BIT, if they think they're going to make a return, they're going to invest. I also think one has to appreciate that there can be contracts, of course, with commercial arbitration, which can reduce risk. You can get political risk insurance. You can believe you're not going to enter into a court process, and maybe you'll get justice in a court process, although in many places, such as Lebanon, it takes a long time to go through the court process. And I know I have a client who's still in the court process 10 years later. But I think to say that there is a direct correlation is difficult. In the past, here's what I would say, I agree with you, that it's more true today than it was 10 years ago or 20 years ago. And that is because I think people didn't even know that treaties existed 20 years ago. So I would get, and I guess you guys had the same thing when we were juniors, you'd get a client comes to you and says, I've had this happen. You say, well, let's use a treaty that goes, what's that? They had no idea, right? And today you have clients calling you and say, we're making you an investment. We want to structure our investment with PwC doing the tax or to get investor state protection. So I think you're right that today for more sophisticated investors, there is treaty protection. But then again, there is so many cases I've seen where the investor has invested, got expropriated. They come to you and you're like, sorry, buddy, no treaty, right? And we can't help you. All you've got left is domestic. So I think that if we look at the statistics, I think they're increasing, that there's this correlation. But the question then is it enough? Even if there is a small percentage, you talked about small, is it enough? And do states really need to bet percentage of their GDP in a case against them in order to get the potential marginal benefit of the BIT? I think the jury's out on that question.
All I was going to say is I think actually Beju said it he said it well earlier when he said it's part of the risk assessments analysis, isn't it, to the extent you're aware of it. So the decision to invest is not made on the basis of an investment treaty, but what sophisticated investors do is they look at the complete regulatory regime, and if they're aware of it, they'll take a treaty into account when they're looking at that regulatory regime, and then they'll look at de-risking their investment as much as possible. So it might factor into the decision, but it's not going to be the decisive or the driving factor, one would say.
Yes. I don't have anything to add. That's right. It's a risk factor, and we don't know the answer. The good news and the bad news, and I think it's both good news and bad news, is we don't get to decide. States need to decide, and I think maybe I'll bring it back to advisory centers. What we want is better informed decisions. And those of you who are economists in the room, maybe you can help us understand better what's really happening. But we don't know.
Yeah, so thank you much for this interesting question, Mr. Amro. Anyone else, please? We still have about 10 minutes at our disposal because we need a question. We are happy to answer them. Philip, please. But if you could just wait for the microphone, because as I mentioned, we have an online audience. So without a microphone, we're going to cut quite a few people off. Thank
you. Okay. Thank you, Martin. Just thought I'll share a case because I was just looking at a GLC, Government Linked Corporation of Malaysia, Telecoms Malaysia. They made an investment in Ghana, all right? And there was a BIT arrangement in 1996, I think. But the Ghana state decided to open the tender again. And the telecoms, of course, raised the BIT. But I understand the case was settled. Why do I mention that case? It's because, interesting enough, when Telecoms Malaysia had a contract with Deutsche Telekom, all right, there was a big dispute over put option, which is to exit if at a certain price. It went to the ICC. When I was talking to senior management staff in Telecoms Malaysia, I say, well, when you're in Ghana, you complain about the fact that the state government decided not to honor an arrangement. Why is it that we decided not to honor an arrangement that is totally legitimate? And yet it involved then a very expensive ICC arbitration costing millions of dollars. And at the conclusion of that, the government, GLC also tried not to honor the award, which was disastrous for the stock market, all right, of Malaysia. I say this in reflective of this whole issue that is interesting that when a government, because governments are now so much involved in investment through their GLC, they kind of do not objectively look at the fact that you are involved in such investments and you want it to be protected. But when it applies back to our side, of course, then we are into a huge issue about rule-based, and I shall not go further. I just made this observation and maybe more learned members can make their comments. Thank you.
Thank you very much. Does anyone want to
I
react to that observation?
Actually, there are two things that strike me. One is the fact that state-owned entities are investors. And so my point about host state, home state actually becomes very pertinent, especially when there's state-owned. I think it's a very good point. I think the other point that's sort of struck me as you were speaking is the fact that a state, whenever it's looking at its treaties, has to think about both its conduct and how it might be sued, but also the investors, its investors. And there is a balance between the two of how you defend yourself, but also how you give your investors the tool to invest and prosecute their own claims. And there's a balance between the two.
Yeah, thank you very much, Philip, and thanks, Beju, for this exchange. We still have a chance for a few more questions. We have a few more minutes. I take this opportunity to welcome Your Excellencies, the Minister of Law and the Minister of Foreign Affairs. Very welcome to the colloquium. And another question or comment, please. Excellent. So I'm very glad that we have a SOAS graduate to ask.
Hi, my name is Mohsen. I'm from almost graduated from SOAS. So Stephen touched upon the subject of cost being a very important factor. And Baiju also mentioned that ISDS is here to stay for like 20, 30 years, but in a different form. So one of the things that I think is not that much talked about is like alternate options. Like MIC, I agree, is a bit of a gray area still being discussed, but what about things like mediation? Like the Singapore Convention has the possibility to replace the New York Convention in the future, maybe. What do you think?
So the question is, are we too narrow in what we think of as ways to resolve these sorts of disputes? And that's one of the working group 3 focuses. The mediation is another focus of the reform effort. Obviously, the Singapore Convention helps because it makes mediation more effective. But I think there's a practical question about how good states are at mediation and how much states want to mediate because of the difficulty in actually participating and making decisions. But of course, the more we have options and more we have intelligent, informed users of options, the better the system will be. It'll be a more nuanced, less blunt system. And that's, I think, a theme that's come across everything everyone's been saying is the more you make it formal, the more you make it too blunt, the less effective and efficient it is.
Pedro, please.
I think it's a very good question. First of all, I think it depends on the case, right? For example, this case that we've talked to is not a case for mediation, right? This is, it's black and white according to both sides. But if you look at other cases, I think they would do very well in mediation. I think the issue, though, is states are not commercial actors. And so it's not necessarily the case that just because it should come to mediation or settlement from a commercial perspective, that the state is going to do it for a number of other reasons, which is why I think mediation has some relevance in ISDS, but I think it's very difficult to get it off the ground in any sort of regular or focused manner.
Yeah. So, do you want to?
Can I ask a question? Can I ask a question?
To Mohsen.
The whole room. I mean, how many people who do in ISDS have seen cases settled during cooling off periods, which is a form of, potentially a form of mediation. Conciliation, it happens, but it's very rare. So we have to, Robert has, but Beju has, I've never had it happen. I would have loved to have it happen times. So part of it is better using the mechanisms that are available, but then we have to ask why they don't work now, and how do we try to do things that will make them work better rather than just more of the same things that don't work.
Yeah, thank you, Mohsen, for an interesting question. Anyone else, please? We still have about 5 minutes. Please don't feel shy. Emilia? No, I'm always conscious of making the best use of the available time.
Hello.
Ah, wonderful. Yes,
Hello. Can you hear us?
we can. Thank you. Please ask a question. But if you could introduce yourself as well, please, just with a few
Yes.
words.
Hi, I'm Putrina Rashikin from Malaysia. It's almost midnight here. Can you hear me?
We can hear you. Please ask your question or make your comment.
Yeah,
We're
thank
looking
you.
forward to
Yeah,
it.
Stephen, I have a question towards you, because the other panels is saying that for Sulu claim is actually an abuse. So what is your opinion in this matter? And if you refer to the lease agreement of 1878, paragraph 4, it's stated that in case of dispute, the Majesty should appoint Consul General in Brunei to settle the dispute. Thank you.
I have a very easy, I don't want to answer the question, but B, I can't answer the question because I've read some news reports about it. I know nothing. Beju says he's read some of it, but I know nothing. And I see compelling arguments made. I have sympathies, but I've read some news reports, so I don't feel like I have remotely an ability to comment on this case. And if I did, it wouldn't add anything to the discourse anyway. So I don't know if anyone else wants to weigh in, but I honestly, I know what Reuters says. I know what Al Jazeera says. I know what Gar says. I don't.
Yeah, I would just say this, that it's a big amount that's third-party funded. The jurisdictional basis requires explanation. The merits require explanation. And I think it's right that Malaysia push for due process to take place such that it has its day in court. And it has the right to defend against an award that it sees as an abuse. On the other hand, I also appreciate the claimants have their right to due process. But I think certainly having read the underlying material, I think I would put it as high as there are questions to be answered. I'd say that.
Thank you, panel.
So thank you very much for all the questions from the audience, and thank you very much for wonderful and esteemed panelists. And I think it's my job to just close my panel, but not the colloquium. So thank you very much, and over to you.
Well, thank you very much. Thank you very much for this interesting session. And now I would like to extend an invitation to the Honorable Datuk Sundra Raju, Director of the Asian International Arbitration Centre, AIAC, to present a token of appreciation to our moderator and to our panelists on behalf of the organizers. Thank you. Ladies and gentlemen, it is a distinct honor and privilege to inform you that we have been joined by highly esteemed guests. The Honorable Dato Sri Azalina Osman Said, Minister in the Prime Minister's Department for Law and Institutional Reform in Malaysia. The Honorable Dato Sri Diraja Dr. Zamri Abdul Kadir, Minister of Foreign Affairs of Malaysia. The Honorable Dato Sri Amran Mohamed Zine, Secretary General of the Ministry of Foreign Affairs. His Excellency Dato' Zakri Jafar, High Commissioner of Malaysia to the UK. Your presence today is greatly appreciated. Thank you for joining us. And now, thank you very much. And now to end this colloquium, we are honored to invite the Honorable Dato' Seri Diraja Dr. Zamri Abdul Kadir, Minister of Foreign Affairs of Malaysia, to deliver the closing remarks. Thank you.
Thank you very much. Assalamualaikum, salam sejahtera. Yang berhormat Datuk Sri Azalina, or we better call her Azza, or Datuk Sri Amran, Datuk Zakri, ladies and gentlemen, since this is a very highly specialized area, I better not to delve into, like the normal speech, because I'm afraid I will fall into trouble. So it's better for me to read through the text, the prepared text immediately. Excellency, ladies and gentlemen, first and foremost, I wish to express my sincere appreciation for this honor and privilege to deliver the closing remarks at this International Arbitration Colloquium 2023, State Sovereignty and Immunity in Commercial Arbitration. My appreciation also goes to the Honorable Azalina Osman, Minister of Law and Institutional Reforms, our strategic partners, distinguished moderators and speakers for your spectacular contribution to this colloquium. I am pleased that this colloquium has attracted great numbers of participants and interest, going beyond just the legal fraternity. As the past colloquium in Malaysia, today's colloquium also witnessed the eloquent discourse on the historical, legal, and diplomatic perspective of the Sulu claims from a wide range of learned speakers. The complexities and nuances on the issues of sovereignty, territorial integrity, and the rule of law were deliberated in depth. I believe these intellectual exchanges have provided a valuable opportunity for us to reflect on the way forward in addressing the complex issue at hand. The first session had a very intrinsic discussion on fundamentals in international arbitration, particularly on the roles of international arbitrators in carrying out their function in upholding the cause of justice. No doubt, the impartiality and independence of international arbitrators are crucial in the effective delivery of justice and upholding the rules of law. These elements are especially important in cases where a sovereign state is embroiled in a dispute as the sovereignty of a state is being put to test. Closely related to the conduct of arbitrators is the thought-provoking issues of third-party funding in international arbitration. The second session went on to discuss third-party funding and the impact of the recent UK Supreme Court decision, which could possibly change the landscape of third-party funding regulation. Our esteemed speakers have acknowledged that third-party funding in international arbitration is an emerging area of concern, with many issues such as duty of disclosure, confidentiality, conflict of interest, and others still remain volatile. Finally, the last session addressed the impact of investment claims on the relationship between investors and the state. Although the topic of investor-state investment arbitration is slightly different from our session's earlier theme, but in the last session, we were enlightened on how investment claims can be better managed, including the possibility of establishing an investment advisory center for states. I'm confident that the London Colloquium has been beneficial to everyone in the local and international arbitration community, and that the participants have gained knowledge and better insight on the issues after this colloquium. Excellencies, ladies and gentlemen, as I stand before you, I'm certain that the indispensable importance of sovereignty to a nation and its peoples needs no further introduction, especially in this region. It is no secret that the Sulu claims, and by extension, the abuse of international arbitration processes, have undermined Malaysia's sovereignty, territorial integrity, and interest. Not only that, fundamental rights and long-standing norms on the rules of law and international relations have been jeopardized. A case in point is the claimant's failed attempt to seize Malaysia's diplomatic asset in France earlier this year, a clear violation of the Vienna Convention on Diplomatic Relations. Excellencies, ladies and gentlemen, the principle of territorial integrity and political independence is an integral part of the international legal order and is enshrined in the United Nations Charter, as well as in other important international legal instruments, including those on self-determination. The concept includes the inviolability of the territory of the state, including territory under the effective control and possession of a state. Therefore, it is rather appalling that Malaysia's independence, sovereignty, and territorial integrity within its internationally recognized borders are being challenged by the sham and abusive arbitration process brought by the so-called heirs of the long-defunct Sultanate of Sulu. The purported final award, among others, made an unfounded claim that certain part of Sabah or North Borneo is a property possessed under the leasehold. Let me be clear, Malaysia does not recognize and will not entertain any frivolous claims made by any party on Sabah. Sabah, where my brothers, former foreign ministers come from. Sabah is recognized by the United Nations and the international community as part of Malaysia since the formation of the Federation on 16 September 1963. In fact, this colloquium is highly timely since we just celebrated the 66th Malaysia Day over a week ago. Excellencies, ladies and gentlemen, despite the landmark rulings by the French and Dutch courts earlier this year that were in Malaysia's favor, we are still facing unprecedented legal battles across multiple jurisdictions in our efforts to overturn the recognition and enforcement of the purported arbitral awards. While these legal actions have come at the expense of valuable resources, funds that could have been allocated to support socio-economic development in Malaysia, I wish to reiterate here, Malaysia will not compromise in the efforts to protect its sovereignty and territorial integrity. What is even more upsetting from this sham award is the fact that Malaysia's fate and fortunes are still being decided by individuals or a sole individual in this case, with no connection to the region? Why must the survival and fate of Malaysia lie in the hands of a rogue arbitrators in Europe? Unjust does not even come close to defining this new form of colonialism. If anything, it shows that from the very beginning, the arbitration process is erroneous, or in terms that are more familiar with the crowd today, mala fide. I hope I pronounced it correctly, because I'm not from the legal fraternity though. However, as much as I am a representative of the Government of Malaysia, I do not wish to turn this platform into a venue to propagate Malaysia's side of the case. Rather, I wish to see things from a bigger picture. As it stands, there is a larger concern that if existing shortcomings and loopholes in the international arbitration process are not urgently addressed, other countries may face a similar fate as Malaysia. The mere fact that a non-state entity, or in our international term, we call it non-state actor, can pursue the concurrent enforcement of fraudulent awards without the consent of relevant parties, or in other words, foreign shopping, should be a wake-up call to all of us here today. How can we, in all conscience, let arbitration be enshrouded by allegations of abuses of process and erroneous actions? At a time where common norms, values, and practices are increasingly at stake, we do not have the privilege to stand idle in the face of blatant misuse of arbitration processes that are happening in front of our own eyes. Without a doubt, there are seditious entities that intend to undermine the integrity and legitimacy of the system for their own personal benefits. This will threaten the very fundamental principle of justice and impartiality of a legal system that many of us believe in. With that in mind, it is time that we reform the third-party litigation ecosystem to ensure a fair balance between access to justice and transparency in litigation actions. Ladies and gentlemen, notwithstanding the varied reactions surrounding international arbitration that arose after the Sulu claims, I wish to echo the statement by my predecessor, the Honorable Tan Sri Anif Ahmad, who is also here with us today, that was shared during the previous Sabah edition of the colloquium last July. Malaysia still believes that arbitration is a crucial instrument to uphold the fundamental principle of statehood, sovereignty, territorial integrity, and the rules of law. In fact, Malaysia is a proud host to the Asian International Arbitration Centre, a global hub for alternative dispute resolution within the ASEAN region. In essence, arbitration is intended and geared to provide a fair, simplified, and just mechanism for entities resolve dispute amicably and in a timely manner. It is based on a mutually agreed framework that focuses on the disputing parties' autonomy. This, ladies and gentlemen, has been and will continue to be the key ingredient to the relevance of international arbitration, something that was glaringly missing in the so-called Sulu arbitration. As much as I believe that we must not let perfection be the enemy of progress, I also believe that stagnation can lead to regression. While the victories achieved through the French and Dutch court rulings thus far may imply that the inbuilt corrective mechanism of international arbitration are working as intended, we must ensure that the current arbitration processes and frameworks will remain resilient against future exploitations attempts. It is only with the continued deliberations from governments, international organizations, and the general public within the international arbitration community that arbitration can retain its legitimacy and effectiveness as a robust and effective mechanism for resolving international dispute. Excellencies, ladies and gentlemen, Malaysia acknowledges the importance of arbitration as part of alternative dispute resolution. The role of international arbitration institutions and their processes in resolving complex issues. As much as the Sulu claims have shocked Malaysia, and I believe the world too, they have also highlighted that the time is now right for an overhaul of the system. In this respect, the Government of Malaysia is developing a State Immunity Act with the purpose of codifying the doctrine of state immunity, including the principle of reciprocity as part of Malaysian law. This law will reflect the general principle of international law on sovereign immunity, including effective service on foreign state, to uphold the rights and interests of parties concerned, safeguard the sovereignty of states, and to preserve and promote friendly relations with other states. It is hoped that reciprocal treatment will be accorded to Malaysia in the event Malaysia is brought to the court of a foreign state in the future. The State Immunity Bill is currently at the policy stage, and we aim to table the bill soon by none other than our law minister. It is only through such reforms that we can continue to preserve the delicate balance between the interests of the nation state and those of the larger community. Towards this end, Malaysia calls upon all countries to come together and take this opportunity to shape the future of international arbitration in line with our international obligations before it is shaped against our favor. Before I end, I wish to take this opportunity on behalf of the Government of Malaysia to once again thank AIAC, SOAS, IDRC, and our legal advisors for your support and cooperation throughout this colloquium. I also wish to thank all participants for your presence and active engagement today. Once again, thank you very much for listening.
Thank you very much. Ladies and gentlemen, we have now come to the end of the London International Arbitration Colloquium 2023. On behalf of the Asian International Arbitration Centre, AIAC, SOAS Arbitration and Dispute Resolution Centre, the International Dispute Resolution Centre, and the Government of Malaysia, we wish to express our sincere gratitude to all panelists and moderators for their hard work and dedication in making this colloquium possible. We wish to express our sincere gratitude to AIAC Deputy Counsel. Of course, I will forget many names, but I will mention Ms. Yi Ting Ko, Thank you very much. Deputy Counsel at AIAC. I will also mention Mr. Danish Chandran, Assistant Director at AIAC. And we wish to express our sincere gratitude to each and every one of you for joining us today, whether in person or virtually. Thank you for your active participation. Thank you for your insightful contributions, and we wish you a good week ahead. Thank you.